My lord, may I have lots of indulgence, my lord?
Yes.
This application, my lord, we're making an my lord, short application for extension of time for holding election, lordship.
Very well, file it.
Lordship, I'm grateful, lordship.
Lord, may I be permitted to mention one urgent listed motion? Urgency is that
Yes.
the private respondent is running a vegetable hut without license.
What he is running?
Vegetable hut
Vegetable hut.
without any statutory license. And very nearer to the
And since when is this hut running?
first April. 20.
Only from 1st April.
Renewed without license. Renewed regulated market
Renewed.
committee license.
When was it?
License of the regulated market committee that was issued in the month of September and
February
up
to
to
6th.
30.
No urgency. File it in the department.
I have already filed.
Yes.
My lord, may I be permitted to?
Don't give the slip.
My lord, may I be permitted to mention, my lord? Urgency is this, my lord, the member of the bar, advocate, my lord, not getting remuneration from Bhatpada municipality. Earlier, my lord, your lordship was pleased to give direction for exchange of affidavit.
Yes.
Nothing has been done.
Affidavit's not exchanged.
No.
Give the number.
Yes.
To be mentioned, it will appear.
Oblige, my lord.
Give notice.
Yes, yes.
May I permitted to mention, my lord, on the last Thursday when the contempt matter was taken up, at that time, my lord was pleased to direct us to mention another analogous matter, which was lying in court number 17, as was assigned there.
Yes.
My lord, for inclusion, my lord.
When is the
On
other
18th,
matter?
On
18th.
18th,
The other matter is
Yes,
appearing.
yes,
It will appear on the 18th.
yes.
I have mentioned.
Oblige, my lord.
May please, your ladyship. I had mentioned this matter for obtaining leave on Thursday, my lord. This is with regard to, my lord may recall, there was an order of my lord that within 6 months an election to the cooperative societies have to be completed, which is expiring on 11th of April, my lord. On 2 occasions, lordship, because of the police inefficiencies, the elections were cancelled. And the period of 11th April is coming near, lordship. I had mentioned the matter. My lord had was pleased to direct that the matter will appear on Friday. Lordship, there was some confusion, lordship. The matter.
Friday it will appear. Give the number.
Lordship, grateful, my lord. Lordship, may I be permitted to mention one matter?
Give notice to the other side.
So regarding an illegal construction, lordship. The
Yes.
state of this illegal construction is very vulnerable, and
The
the
please use the microphone.
the state of this illegal construction is very vulnerable. Like it can fall at any time, and also the construction is made in such a way that cracks have started appearing on my property. So, lordship, also the returnable date is also over long. So, kindly, lordship, this be included in the daily list.
And then today is not the day for mentioning for inclusion. Monday I have taken up all slips. Why were you not there?
Lordship, that was not there.
Please wait for your turn.
Permitted to mention for applications for contempt applications.
No inclusions. Call the list, please.
My lord, typical error was there, my lord, in the order.
Typographical error
Yes, my lord.
in the order.
Yes, my lord.
What is the date of the order?
My lord, it will be
Date of the order
27 to 24,
27th of February.
February 20.
We are in April. What were you doing for the last 1 month? And what is the error?
My lord, it was typically written as Kolkata Municipal Corporation instead of State of West Bengal.
Give for correction. Yes,
my
item
lord,
1.
My lord, may I permit to mention a matter?
Mentioning.
Restoration application.
No.
I beg to appear on behalf of the respondent number 9.
Yes.
So far that matter is concerned, my lord, B by H by 21, 26 and 23, Dr. Suresh Banerjee wrote. Lordship, kindly see on the last occasion, my lord, yesterday, my lord, Lordship was kind enough to put me a question. My lord, when this was, my lord, regularized. My lord, read petition page number 50, Lordship will find Thika controller, my lord, issued a letter on 12/7/2022. Read petition, my lord, page 50.
Yes.
Well, this is the letter 12/7/2022 addressed to the Director General Building, Kolkata Municipal Corporation. And my lord, second paragraph I'm reading, my lord. Hence, a provisional NOC is hereby issued in terms of the section 6(3) of the West Bengal Tika Tenancy Rule. in favor of the applicant for the purpose of obtaining necessary construction plan from your good office if deemed fit. And my lord, when this whole process was pending before the Thika controller, at that point of time, Kolkata Municipal Corporation issued a notice for demolition. That is page 46. We preferred one writ application before this honorable court. Honorable court, my lord, discussed the entire episode and directed, my lord, since, my lord, the process is going on, as a result of which, my lord, Lordship was kind enough, page 47, in view of the order passed by the Honorable Division Bench, order passed by the Executive Engineer dated 29th April 2022, Lordship kindly consider, my lord, the order passed by the Thika Controller on 12/7/2022, when they are in session, my lord, in terms of the, my lord, Division Bench order, at that point of time, in the month of April, Kolkata Municipal Corporation issued a further notice to demolish the structure. We immediately preferred on writ application. This honorable court was kind enough to observe page 47, in view of the order passed by the Honorable Division Bench, order passed by the Executive Engineer on 29th April 2022, which is impugned in the present writ petition, became redundant. Well, that being the situation. Now, Lordship, I am drawing Lordship attention, page 50, I am already drawn. Then, my lord, page 51 of the writ petition, Lordship, kindly see, the KMD authority, pursuant to a letter issued by the officer in charge of Beliaghata Police Station, page 51. Lordship, got it?
Yes.
Kindly see, from Deputy Chief Valuer KMDA KIT Wing, the officer in charge Beliaghata Police Station, inspection report of premises so and so. Then, my lord, content, in connection to the letter dated 12/12/2022 and 12/12/2022, please find and enclose the herewith a detailed physical inspection report in connection with the above mentioned plot for your further course of action. Lordship, kindly recall, my lord, the order passed by the Thika Controller on 12/7/2022. Subsequently, a fresh initiative was being undertaken by police and KMD authority. It is not the duty of police, subject to correction, my lord, to do all these things. Lordship, kindly turn to the next page, page 52, that report of KMDA. Then, my lord, 53, Lordship will find, my lord, 53, my lord, something, my lord, surprising. Here is a letter, my lord, addressed to Manos Kumar Bishwas, writ petitioner herein, by the Government of West Bengal, Office of the First Land Acquisition Collector, Kolkata, so and so. It is not a reply of RTI. It is a normal communication and reply immediately, my lord, received on 21/3/2023. 21/3/2023. Then, my lord, Lordship, kindly see page 54. This is to officer in charge once again by the additional land acquisition officer. So, my lord, our humble submission subject to correction, my lord, the police authority cannot interfere in this fashion so far as civil dispute is concerned. Now, my lord, kindly turn to, my lord, our report, my lord. My lord, during this period, when this type of, my lord, things are going on, they encroached upon our property, my lord, we move before this honorable court. Lordship, kindly see page 130, 131 and 132. And this honorable writ court was of the opinion, it's a civil dispute. My lord, this is, my lord, my exception filed by Bimal Prakash Sharda in the month of October 2023. Lordship, got it?
Which page?
130. Date may kindly be looked into, my lord.
130.
130 of my exception, my lord.
All right.
It's a voluminous document, my lord,
Yes.
by Bimal Sharda, affirmed, my lord, in the month of October 2023. But I'm drawing lordship attention, my lord, page 130. Date, my lord, may kindly be looked into 8/12/2022. So, my lord, the NOC from the Thika Controller 12/7/2022, and subsequently, my lord, new proceeding initiated by the other instrumentalities and state. And then, my lord, lordship, kindly see, my lord, I'm reading the first paragraph. The petitioner is aggrieved that certain person allegedly associated with the private respondent have broken a portion of a wall of his Thika tenanted premises 76/H/21, 22 and 23. Then, my lord, kindly see, the petitioner has filed a suit being number, title suit number 130 of 2022 before the learned civil judge, and skipping one line, there is a status quo order. In respect of the suit property, it is submitted, private respondent private respondent have in violation of the order of status quo broken the petitioner wall. Then, my lordship, kindly turn to the next page. Entire discussion before the Thika controller. And finally, my lord, there was a direction to the police authority to look into the issue. Then, my lord, kindly see 131, 132, and 32, 157. 157. There was in contempt proceedings. 157, my lord. What started as a writ petition for inaction by the police who assisted the petitioner in constructing a wall has snowballed in a controversy as regards the title of the property of the petitioner, the private respondent. There is also an allegation the petitioner property does not exist in the eye of law. All these matters are not brought to the notice of this court on the day when the order was passed by in the writ petition. The private respondent are guilty of approbation and reprobation. But in the instant case, we are writ petitioner, they are private respondent. And then, my lord, there was a direction, my lord, to pay cost, my lord, that was, well, that being the situation. Now, lordship, kindly see, my lord, we have preferred one, my lord, the civil suit before the civil court, and they also preferred a civil suit in the civil court that is pending, my lord. Then, my lord, kindly see, yesterday, the document which I am trying to show, and subsequently I have circulated a copy to my learned other side. Lordship will find, my lord, this is affirmed by Bimal Prakash Sharda on 5th day of March 2024. Small affidavit, my lord, with that map, my lord.
That map is already here.
Here, my lord. Kindly see, my lord, at the bottom, though, my lord, lordship was kind enough not to go through the map because it is to some extent an old map. Yet, my lord, I'm just indicating, my lord, what I intend to submit. Lordship will accept it or reject it. Achha, বোঝা যাচ্ছে না যশোর নিতে চাইছেন না আমি জাস্ট দেখে ছেড়ে দিচ্ছি লর্ডশিপ কাইন্ডলি কাম টু annexure D11 at the bottom. Lordship will find, my lord, B by 76 by H by 21, 22 and 23 at the bottom, my lord.
At the bottom, CIT land, you can see.
Lordship, at the bottom,
Bypass.
Eastern bypass, and thereafter, my lord, B by 76 by H by 21 and 22 and 23. It's my land, my lord. It's my land. And then, my lord, I am reading. I'm drawing lordship attention.
Your land means the rectangular
Yes,
portion.
Yes,
Green color
yes, yes. At the bottom, eastern bypass facing, my lord.
Yes.
Lordship, kindly turn to the next page, annexure E. Here, my lord, some local resident in the year 1990 wrote a letter, my lord, page 13. Lordship will find page 13, the date 3/3/1990. My lord, I am reading, my lord, page 11, paragraph 1. গত ইংরেজির 20 ফেব্রুয়ারি 1990 আনুমানিক রাত 11:30 সময় কিছু অচেনা সন্দেহজনক লোক একটি জিপে কোরিয়া কর্পোরেশনের প্রেমিসেস নাম্বার B/76/H/21, 22 and 23 মেইন গেটের সামনে, যাহা বিমল প্রকাশ সারদা তার মা ও বাবা আমাদের মতোই সরকারের স্টেটের নিকট ঠিকা প্রজা হিসেবে বিগত 25 বছরের জন্য ভোগ দখল করিতেছেন। উক্ত লোকেরা মেইন গেটের তালা বন্ধ দেখে নিজেদের সন্দেহজনকভাবে কিছু আলোচনা করে। 2, গত ইংরেজির এত তারিখে আনুমানিক সকাল 8টার সময় আবার সন্দেহজনক 7-8 জন লোক হঠাৎ করে মেইন গেটের তালা ভাঙার চেষ্টা করে, কিন্তু আমাদের প্রতিবেশীরা সম্পত্তি বিপদগ্রস্ত মনে করিয়া নিম্ন স্বাক্ষরকারীরা কিছু অধিবাসীর উপস্থিতিতে এবং মধ্যস্থতায় উক্ত লোকেরা চলিয়া যায়। কিন্তু তাহারা আমাদের শাসাইয়া যায় যে যেভাবেই হোক বলপূর্বক আমাদের উক্ত প্রতিবেশীর সম্পত্তি দখল করিবে। এইরূপে বেআইনি জোর করে এবং বলপ্রয়োগের দ্বারা অন্যের সম্পত্তি দখল করিতে গেলে আমাদের এলাকার শান্তি এবং নিরাপত্তা বিঘ্নিত হতে পারে। My lord, they are still, my lord, they are uninterruptedly, continuously, my lord, that making that, my lord, attempt till today, my lord. My lord, page 13, my lord, the signature appearing, my lord, of the local inhabitants at that point of time. Then, lordship, kindly see, my lord. My lord, 2 documents filed by the Kolkata Municipal Corporation, my lord, the 2 report.
Aren't we transgressing from the original point? Why are you showing all these things?
Because, my lord, because this property for a considerable period of time since the date of their purchase, my lord, they are trying to occupy and grab this property. Even at a point of time, this property is mortgaged. I am showing one document before
Then
the.
you have approached the civil court.
Yes, my lord, that matter is still pending. In spite of that fact, when an order is non-est in the eye of law, they are trying hard before this honorable court to obtain any order and to settle this, my lord, civil dispute. That is why, my lord, I am producing all this document. Lordship may accept or may reject it. I am showing one or two documents. I will conclude my hearing, my lord. Lordship will find, my lord, the report filed by the STICA controller. One document, my lord. Now, my lord, pursuant to the direction of this, my lord, honorable court, THICA controller passed one, my lord, filed one report. Though, my lord, the Lordship will find, my lord, Lordship, this is affirmed by, this is a report of Deputy Controller, Kolkata THICA Tenancy, 9/1/2024. Lordship got it?
1 minute.
Kindly wait. It's a thin.
দেখুন তো ওখানে আছে।
To Mr. Josh Deora, addressed to Mr. Josh Deora, the learned state advocate. THICA controller একটা report দিয়েছে।
না এটা না।
9/1/2024. Now, Lordship, kindly see. Lordship got it?
Not yet. Is it by way of an affidavit?
No.
It's a
Only, my lord, a report
report.
circulated 9/1/2024. In terms of the above, a report of officer in charge Narkeldanga Regional THICA Tenancy Office is enclosed herewith for your kind perusal and necessary action.
Yes.
Lordship got it? Last page, my lord. A sketch is there.
Sketch is there.
But may I hand over my copy, my lord?
No. The document that you are reading
Yes, my lord.
contains a forwarding letter dated 4th of January
Ye-
2024.
4th of
Filing-
January, my lord. Second page is 4th of January letter.
Yes.
Forwarding
Then-
report in connection with WPO number so and so.
Right. Then where
Last
is
page may
this?
kindly be looked into, my lord.
There is no sketch.
Sketch is not there.
Whatever it is.
But kindly see,
Yes.
I'm just, my lord, after making my submission, I'm handing it over. My lord, at the very top, my lord, my premises 2908.
Is
Then-
the sketch like this? Is this you are relying upon?
Yes, my lord, at the top.
All right.
Lordship will, at the top, my lord.
At
Lord,
the top, EM
Common
bypass.
passage, EM bypass.
Common passage.
Then, my lord, common passage 2908 square feet, Pakka,
Yes.
1-story building. That is my building, regularized by the THICA controller and Kolkata Municipal Corporation. Then, my lord, certainly there is a tin wall. My lord, few minutes ago, I have drawn Lordship attention. One, my lord, writ application was there when this tin structure was created. Then, my lord, kindly see Jongle 84 Canal Circular Road. Now here, my lord, Lordship, kindly, my lord, recollect the sketch map which I have, my lord, is illegible sketch map. Now 84, my lord, Canal Circular Road. Then again tin wall. Then, Lordship, my lord, 86 Canal Road. Then, my lord, kindly read land of. But I cannot take his name. He is not implicated as party. I restrain myself not to make any allegation because he's not, my lord, made array of party, my lord, that being the situation. So, my lord, this is, my lord, so far the report of the THICA controller. Now, my lord, one document I'm showing. This is the report of Kolkata Municipal Corporation. My lord, filed by, my lord, their executive engineer. Only one document, my lord, I will conclude my argument. My lord, this is one Badal Roy. Dated, my lord, Badal Roy, my lord, report. Yes, my lord, Lordship got it. Only one document, my lord. Page 32. Oh, no, not writ petition. The report filed by, the report prepared by the executive engineer, civil engineering. Page 32, my lord. My lord, this may kindly be allow, my lord, to read the whole 1 or 2 pages document, my lord. Page 32. None is present for the certificate holder bank. Heard the learned advocate for the interveners at length from the submission made by the learned advocate from the intervener. it is absolutely clear that it was due to wrong submission made by the certificate holder bank based on search report carried out by MS A. Chatterjee consultant. The order of attachment was issued further by an order dated 2nd May 2003, the date on which the interveners filed the petition. Learned receiver was directed not to take any further step in respect of the property being number B by 76 by H by 21, 22, 23 Beliaghata Main Road, Kolkata. And the certificate holder bank was directed to file objection to the petition. It is observed that bank was granted time to file the objection, which was filed on 15/9/2004. In the objection filed by the bank, it has been submitted that the inspection and on personal verification made by the learned receiver, it was ascertained that the premises number 84 Canal Circular Road has been renumbered as B by 76 by H by 21, 22, and 23 Beliaghata Main Road. Now Dr. Suresh Banerjee Road. Whereas no such finding have been observed in the report filed by the learned advocate, learned receiver, and also that the bank could not produce any document in support of such submission. Accordingly, this bench is fully satisfied that since the property being 84 Canal Circular Road could not be identified properly, the property being number B by 76 by H by 21 and 23 Beliaghata Main Road has been attached due to inadvertence. Hence, it is order, my lord. Hence, it is order. Let the order of attachment issued by the turn to the next page, my lord. Order number dated so be withdrawn and cancelled, and let the property being number so Calcutta be released from attachment. Well, that being the situation. But considering all these aspects, at least 2 civil suit is pending. One filed by us, suit for declaration and permanent injunction, and they filed one, my lord, one suit, my lord, seeking declaration from the civil court that there is no existence of B by 76 by 21, 22, and 23. These 2 matters are pending in the civil court. My lord, we think, my lord, is a civil dispute. Police cannot interfere in any manner whatsoever. My lord, the writ petitioner on number of occasions took the help of state and its instrumentality. And my lord, a person's name is appearing in the report of the, my lord, the Thika controller report. My lord, taking into consideration all these aspects, lordship, kindly, my lord, this is my humble submission.
Well, we have very brief submissions. The thing is that this court matter is considering whether there is an unauthorized construction or not, whether it is to be demolished or not. This is the primary issue because no other issues to be considered by this bench. Now only it appears from the records that a proceeding was initiated as far back as in the 2004. The proceeding was initiated in respect of construction on a particular site. Now, site is now in dispute. Now, on a site, my lord, which was identified by us, initially, my lord, it was 76 by P. You can see, my lord, page, the bunch of documents, my lord, they have submitted Mr. Chakraborty, that the order is there. You can see at page 165. This was identified unauthorized construction at premises number B by 76, H by 23 at page 65.
Yes.
At the top, my lord, you also see the demolition case number 38 D such and such 2003-4. And my lord, the premises, the subject premises proceeding under section such and such of the KMC Act 1918 in respect of premises number B by 76, H by 2 by 23. And the proceeding was initiated in respect of structure, and ultimately the authority, my lord, Special Officer B, passed an order for demolition, subject to certain conditions. One of the conditions was that he has to bring, my lord, the NOC from the Thika controller. Therefore, the premises which is identified that was taken into consideration is a Thika property. Therefore, any construction to be made on that particular premises, no objection certificate is to be given. But the authority concerned, my lord, although it is required, my lord, before making any construction, but the Special Officer building, my lord, allowed the construction to remain subject to production of that particular document. Nothing was, my lord, done.
But then there is a provisional certificate from the Thika controller that has been shown.
That is very later on.
Later on.
Later on. Not
Yes.
initially.
Yes.
Not initially.
Then the A special officer permitted retention subject to the
Subject to
certificate,
production of that particular document.
and that has been produced.
That has been now been produced. Therefore,
Yes.
we have also at the end, we have granted the regularization plan.
You have regularized.
Regulation plan has all been granted after production of that particular document, keeping in view of the order of the division bench. This is the position. Now, my lord, the dispute has arisen that a site, my lord, somebody is claiming that is a 84 Canal Circular Road, and somebody is claiming my lord, the 76 and the B by H by 20. Question is, my lord, that we have to proceed, my lord, whether a particular structure, wherever it is, my lord, in any particular site, that was identified as unauthorized construction. If that is allowed to be stand, irrespective of the consideration that it is on my lord 84 Circular Road or my lord B by 7323, that may not be taken into consideration by this writ court now. Now the thing is this particular the proceeding, since it was not acted upon, we my lord subsequently found that the unauthorized construction still is there and no document was available because immediate action was not then. Then my lord, we initiated the proceeding in respect of the same my lord, the structure once again in the year my lord 2021.
When did the Thika controller issue that certificate?
Thika controller my lord issued the certificate my lord after the division bench granted them liberty to obtain within a particular period. If he does not, my lord, then the court, my lord, directed us to demolish the structure.
Right.
That was the order of the division bench. Earlier to that, my lord, we initiated proceeding.
Yes, I
He-
followed.
he
18
literally
years
said, my
passed.
lord,
In the meantime, the certificate was not obtained. Thereafter, by virtue of the division bench's order, the certificate is obtained.
initially, my lord, when we, my lord, initiated a fresh proceeding, in this was the same structure at the site premises, there we mentioned that both the premises numbers and both the names of both the persons in the notice. Bimal Prakash Shadde was there, Manoj Kumar Bishwas was there. That proceeding, my lord, ultimately, it was challenged by Mr. Chakraborty's client before this court, well, referring to the retention order of 2003-4. Then we submitted that since, my lord, there is a precondition, our submission was before the single bench. This was the precondition. Since he has failed to do that, therefore, my lord, we can demolish it. But so far the initiation of the fresh proceeding was not possibly the correct procedure was adopted by the author.
Now, after the division bench's order is passed, after you have regularized or you have permitted retention, what is to be done?
But therefore, I am submitting the structure to retain. Now that they have to dispute, they resolve the dispute whether it is a 84 or 7. But on the basis of that, it is on 84 Circular Road that it is to be demolished. Now he is claiming that it is on 76, but the structure has been allowed to be retained.
Where is the question of demolition if the structure is
Therefore, does not arise. That is my point is there. Therefore, I cannot demolish.
irrespective of the fact whether it is
Yes, to be the fact
84,
or whether it is on
or-
84 or 76.
so you cannot demolish.
I cannot demolish, particularly in view of the order of the division bench. And on production of the certificate from the Thika controller. But this is the short issue before the lordship for consideration. Now, the order which they have challenged in the writ petition, illogically see this order is not in force at all, non-est rather.
Which page?
At page, my lord, the writ petition illogically sees, my lord. September 2021 at page 26, prior raised at premises number 84 Canal Circular Road, Kolkata, and thereby to give effect to the order of demolition dated 30th September 2021. This 30th September 2021 is subsequent proceeding which was initiated by us, but the court moderate said that proceeding is non-est. That proceeding cannot be, because the division bench order is there.
Yes. The division bench's order is there.
They are there. The
Your
court said because
submission-
it was an issue.
It is a submission that it is not.
It was submission, and the court also, my lord, proceeded on accepting my submission. The court passes an order. Of course, that was my submission. Because I cannot say, my lord, the industrial sales and structure, the proceeding will be initiated twice. You can see the division bench's order because the court accepted, therefore the court did not go into that issue at all.
Yes, 9th of March 2022's order.
Yes. Then the court proceeded regarding Thika controller
Ye-
certificate.
That means your submission is that at this stage there is no scope for demolition because
scope for
regularization has been put. This is your common substance of your. What would you like to say in reply? Where is the unauthorized construction that is? Yes, because we have transgressed so much. We have transgressed so much that the very idea of the unauthorized construction was blown away. It was the ownership.
I submitted, but when I moved the writ petition, my case was just this much. That corporation has tried to avoid the issue of construction by coming up with a case that two premises are same, which was not their case when the demolition proceedings were initiated. I will show your lordship, my learned friend has shown 2004 demolition proceeding. Kindly see 2021 demolition proceeding. It is their case. Now when the court says in contempt that why haven't you done it, at that stage for the first time, corporation came up with a stand that we were under a wrong impression that both are same premises. And then thereafter left it to the court that if the court says it is different premises, we will demolish. Corporation is not taking a definite stand.
That was not our stand.
Yes, kindly see the demolition proceeding. Kindly see page 33 of the writ petition.
34 is the order of
Yes,
demolition.
before that, also see the demolition, the stop work notice and the hearing notice. Kindly see they are addressing for two premises.
84 Canal Circular Road and within bracket 76 by H.
Yes, thereafter, your lordship will kindly see
Next page, demolition.
next page, the demolition proceeding,
Yes.
demolition order.
Hmm.
No, kindly see, below page 33 last, you are directed to appear before executive engineer in with relevant document in support of your alleged construction work which is going on has been raised at 84 Canal Circular Road. And next page, kindly see page 34. Whereas issue of show cause notice in respect of construction work which has been raised at premises number 84 and 76 SC Banerjee Road. Then come to the ordering portion. Construction work is requires to be demolished. As per, I am competent to pass the order for demolition. You are hereby directed to demolish construction raised about 325 square meter more or less at premises number 84 Canal Circular Road and 76 H by 21 within 5 days. Then kindly see above construction, last 3 lines has been bounded on the north, has been bounded by on North Blacktop Road and premises number B76 by H by 39. So how can they say that 84 and 76 by H are one and same? Since no objection has been granted for 76 by H, therefore no further demolition can take place. They themselves are saying that the improved construction work, on the north of that improved construction work, there is a Blacktop Road and premises number 76H. So how can you now say 76H?
Let him found out the two structures. One in 84, which my land is contending, that is in 84, that is to be demolished, and there is another structure in 76 nearby, and that is to be demolished by the order of 2004. Let him found two structures.
76 is not to be demolished. The second structure in 84 is to be demolished. That is our case. 76 by H, they have already gotten no objection. My writ petition is not for that. So therefore, first I am saying I am relying upon corporation's own order of demolition to say that their new case which they are making, that 84 and 76 is same premises, is not correct. Because the special officer, executive engineer, has identified the unauthorized construction. He says that on the top of on the northern part of the unauthorized construction, there is a road, and thereafter there is a premises 76. So this is the first document to show that they are not correct in their assessment. Now, second document we have shown here, report of the land acquisition collector. which also says that 84 and 76 is different. TICA controller is the third authority, who also says that 76 returns are being filed. For 84, there is no return. That means it exists. So you Lordship has three reports, two reports apart from corporation to suggest that there are different premises. Now your Lordship will kindly come to my learned friend's submission that the second order is honest. How can my learned friend say that? I don't know. Well, your Lordship will kindly comes back to the order dated 9th March. Kindly read that order with me once, my lord. Page 40, 9th of March. Here the corporation files the report and they try to justify. Kindly see the second line. From the report in the form of affidavit, it appears that construction in respect of which present demolition proceedings have been initiated is the same construction. That is their report. Court is just reading from their report. That present demolition proceedings, that is 2001 proceeding, have been initiated is the same construction in respect of which demolition proceedings have been initiated earlier in 2003-4. Earlier demolition proceedings culminated in corporation permitting the present appellant to retain construction in question upon complying with 4 conditions. One of the conditions was that he must furnish NOC. Mr. Ghosh, learned counsel representative, says that NOC from TICA controller has not been furnished till date. Kindly note, this is the submission. Therefore, for breach of that very important condition on which the appellant was allowed to retain the construction ought to be demolished. However, he fairly concedes, this is their submission again, that second demolition proceeding initiated in respect of the same construction and misconceived may be treated as honest. Thereafter, kindly see the court's order. We are, however, for the ends of justice, we direct TICA controller to pass a reasoned order on application made by the appellant on January 24th. If the TICA controller issues a no objection certificate as has been asked for, corporation should accept. If it does not issue such no objection, for corporation may take steps in accordance with law. We have not gone into the merits of the claim. So the court leaves it open. If you get a no objection, then you will decide accordingly. Thereafter, kindly see, below what happens. Further notice is issued by corporation. At page 44. Again, kindly note this date. This is 2022 at page 44. So corporations, Mr. Ghosh's case that he considered, that is not accepted by corporation here. Kindly see regarding unauthorized construction concerning premises number 84 Canal Circular Road and premises number 76 by H by 1. This is a fresh notice. And they challenge this notice, the other side. Kindly come to your Lordship's order, page 45. Here also corporation has not considered before your Lordship that there is no other demolition proceeding apart from the 2004. So that order of demolition proceeding of 2021 has not been withdrawn by them, nor has it been annulled, cancelled by any appropriate forum.
The moment the expression "and" is used in between the two premises number, does it not mean that it is the same premises?
Yes, it's two different premises. There is an unauthorized construction in 84 and 76. If you give no objection,
If that be so, that means two separate unauthorized constructions?
yes, two separate unauthorized constructions. One has been regularized for 76 by production of a no objection certificate. The other construction in 84 remains. That has been my case throughout.
But then you cannot substantiate. I don't think.
Well, the three authorities have substantiated about the existence of two separate premises. Corporation is only confused about identity. I accept that case. Corporation is not in a position to determine. Now, when there are other authorities which are determining that there are two separate premises, corporation now cannot say that I am not in a position to identify. Then the corporation has to take the help of the other authorities for identification.
Say that also number that.
In the present proceeding, was any direction passed for spot inspection to ascertain the two?
The Lordship has passed. Or by land acquisition, by
Yes.
corporation, by
Right.
Thika controller.
And what is the
And now kindly see the corporation's report in this regard.
And land acquisition.
Also one of the land acquisition collector's report. Now kindly see the corporation's report.
Submission, my lord, continues. My lord,
I am not on fact. I am not at all on fact. I am saying this is the only issue. That there are two premises, there are two unauthorized structures. One has been retained, the other not. This is the report.
But I am submitting, my lord, that before the division bench, it was more not my submission. I submit, my lord, on the basis of the report affirmed by my authority. That report, my lord, not my lord, the mayor, my lord, the verbal submission before the court. The report was submitted. The report says, my lord, the same structure. Again, my lord, the proceeding has been initiated. Therefore, my lord, the construction, the same construction. My landman is saying that number, my lord, showing that the two premises are there. The different premises. Question is, if there are two premises, there should be two different structures. One is asking for demolition, another not to be demolished. What is the two structures are there?
That's the case.
What are the two structures?
Well, Lordship, may I suggest this, my lord? Your Lordship may send any officer of your Lordship's court, any learned advocate as an officer of your Lordship's court, without notice to any of us. Let them go and visit and find out 8476 whether
the corporation officials are not able to identify, and you think the court, the advocate from the court will go and identify it?
they have identified. I am saying the Thika
court matter is pending with the appropriate court.
No, that is
In
not.
order to
We are
not-
not.
Yes.
Well,
Listen, civil court is regarding ownership.
Yes.
Unauthorized construction, what will the civil court do?
And 76, they are trying to show, my lord, this is identical. They are trying to show this is
They don't say identical.
I don't say identical.
No, please don't confuse the court.
Yes. Well, kindly come to the report of the land acquisition collector. Just one page. Page 52 of the writ petition. These are reports of statutory authorities.
Smart
Well,
map.
I can't go
Smart-
behind this.
The smart map of KMC.
I have the smart map of the KMC also.
It's the acquisition on the 84.
This is one of the peculiar stand which has been taken. Premises does not exist. Premises has been acquired. Acquisition has taken place and now the premises has vanished.
And the report, earlier report, exception, earlier report.
What are you showing?
Well, I kindly come to page 52 of the writ petition.
Yes, please.
Kindly see, this is by the KMDA. As per physical observation along with GI tagging, it has been found that. Kindly read, my lord. Serial number 23, acquisition of premises in question has been done in the year 1972 in the presence of first land acquisition collector bearing premises number 84, 90 and 88, 81 by 2 by 1. 2 kata, 2 chata, 5 square feet land has been acquired from 84 Circular Road by LA Department to make service road beside EM bypass in the year 72, proportional land value credited to the owner. As per demarcated site plan of erstwhile KIT scheme, premises number 84 having unauthorized one-story pakka structure. In this verification, it has been observed that premises bearing number 76 by H by 21 Belegat is not found, actually not exist within such scheme and also not in that area. 84 is identifiable. Now kindly see the Thika controller's report which my learned friend has drawn your lordship's attention. His file the Thika controller has made a 2-page report. He has also said for 76 H by 21 returns are found. There are no returns for 84. So existence is admitted. I do not know whether after all this, how can corporation come up with the stand that 84 I cannot identify? It is nobody's case that 84 has vanished or 84 or 76 by 1 is same.
No, renumbered in one place it was
That
mentioned.
corporation is saying.
Corporation is saying that it has been renumbered.
But Thika controller is saying that 76 I have received returns. 84 there is no return.
Yes.
So therefore, it is merged with 76. That is also not there. Then when was it renumbered? If there is acquisition which has taken place in 1972 of part of 84, then let them produce the records in support of their case. But this renumbering case, I do not find from their conclusive report, which they have filed before your lordship. When your lordship has asked them to file a report should indicate everything. Now kindly have a look at their report, what they are trying to say. Their confusion they have highlighted that we cannot identify. But what is the actual situation, they can't say, even in their report. Kindly come to page 5, para C first. Kindly see, it says in the incident case, controller issued a provisional NOC in respect of 76 in favor of Bimal Sharda. Since in one occasion I issued a letter dated 29th April 22 to Bimal Prakash Sharda, Manoj Kumar Vishwas, asking them to submit NOC in respect of premises number 84 and premises 76. It was my bona fide understanding that premises number 84 and 76 are same and one on premises. On bona fide understanding, not on the basis of any
Records or anything.
number one. Number two is, so this is the starting point. Then he says that we have now, petitioner has now sought to dispute the identity of premises in question as premises number 76, in respect whereof NOC was granted by Thika controller. Since again, according to my bona fide understanding and belief, premises in question is known by two different numbers as well as two different street names. Lordship probably, the greatest of respect, cannot rely on this. He is bona fide understanding. Your Lordship can.
What is your suit for?
My suit is for encroachment. That they are coming in within my property, 84. That is something else completely. I am not asking for any order in respect of that. I am only trying to enforce 2021 demolition order, which according to my respectful submission has not been withdrawn nor annulled and has its force.
Very good.
Now kindly see, my lord, paragraph 7. Page 7, paragraph 7. As per IB record, premises number 84 Canal Circular Road comprising land area 18 kata footage belongs to East City promoters such and such. The land area mentioned in IB grossly matches with area mentioned in deeds, also matches with area bounded by a boundary wall. So their IB record is showing my premises. Then second party claimed land in question belongs to 3 premises. This is their case, other side's case. But my property exists. Whether it belongs to me or them, that the civil court will decide. Then kindly see last paragraph, premises 76 H by 21, 22 are recorded in favor of second party in our IB record. So his IB record records 2 premises as different premises. Then even next page he says details of IB record in favor of second party. Premises number B76 H by 21, owner Bimal Prakash Sarda. How can my learned friend say that there is one premises? So therefore his own bona fide understanding which he recorded in paragraph 3 was not correct.
As per smart map.
Then kindly see as per smart map, same page. Land within the boundary wall falls in premises number 84, 85, 86. Premises number according to smart map. So even the smart map also records 84.
Very well, I have followed it. Let us see what can be done.
I am only saying this, Malad,
Submission only.
only one
One writ application being number one Malad
Just
title
10
code
minutes.
177
my
of
your lordship,
2023.
may your lordship give me
Where
only
they are
5
taking a
minutes?
decree for declaring that 76 by H by 21, 22 and 23 to be a non-existent. They have prayed for before the civil code 177 of 2023, my lord, declaring these premises as a non-existent premise. Thereby, only 84 will be there. Thereby, my land of government will be there. That is the prayer.
Sir,
in the civil code.
may I
That
submit
is
only?
page 31 of my lord, the written version. Against my lord, the report of the executive engineer, Kolkata Municipal Corporation.
And show the report.
Page
Report of the final
31,
report.
my lord, in paragraph, my lord, page 31 have very categorically stated, this is their title suit pending before the chairman. Page 31.
No.
Pending before the
Here the
civil court. Civil court.
thinking, my lord, the premises to be declared as a non-existent.
But
My premises. Page
Whatever
31,
declaration,
Your suit is for declaration.
my suit is declaration and permanent injunction. After filing of the suit, my lord, status quo have
All
obtained.
against him.
that is
At
not
that point
against
of
me.
time, they encroached upon. I preferred a writ application. Thereafter, my lord, they have preferred this, my lord, civil suit before the CM. Prayer is, my lord,
And there is a separate suit filed by the petitioner for encroachment also. So 3 suits.
177 of
Only
2000.
one.
Well, I
thing is
No, I have filed one suit.
Well, I related my same
have
submission.
Their suit is against plot number 85, 86.
And their suit is not against 84.
Page 31
85,
can be looked in. I am not, this is my prayer, my lord, this is the land belongs to the Tika controller. I am a tenant.
But I have a
31
humble
may
prayer,
kindly
my lord.
look in. On
Well, I'm just reiterating my submission, my lord. The second proceeding.
No more reiteration. I am completely confused.
Yes, I have
That is
one.
why
one
There is no
submission.
reason
Sir,
to
kindly-
be confused, my lord.
Well,
It
kindly
is
give
not
me-
matter election. Once you election going to the issue, election found, my lord.
Yes,
There
nothing-
is, it is a small issue.
Nothing is there.
Everything.
Even corporation's report makes it very
But
clear.
because we have withdrawn the second proceeding.
Where?
Therefore, that is the result of that order, which is now asking for the cancellation.
page,
9th March order of the division bench is clear because we have withdrawn the second proceeding.
page 107 of my rejoinder, my lord, their inspection report. They have, my lord, the
Well,
executive
kindly-
engineer
kindly-
place inspection.
No further repetitions, please. I have to go through all the papers.
Close the hearing also.
Well, kindly give us 5 minutes on another day.
Appropriate.
Why?
No,
I-
No, no, no.
no.
Well, I tell you the truth. Mr. Shandal
Close.
is leading me, my lord.
Close.
Who is
Mr. Subish Shandal is.
Yes, so what?
Personal,
No, no. You are here.
personal difficulty.
Nothing.
Well, his
Hearing
personal
concluded.
difficulty was not there, my lord.
5 minutes.
Hearing concluded, CAV.
Well, if your lordship wants, we can give a short note.
Please, no fun.
Within no sense, we cannot say.
But kindly give us, my lord. Mr. Shandal will take only 5 minutes. By
No,
the
no,
walk.
no, 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 no.
Alright.
Call the next matter, please.
This is my application.
Yes.
It's a simple application, Lord, formal application for amendment in the writ petition. I tell your lordship, Lord,
This is an application.
application for amendment of the writ petition. Lord, what had happened is that when the writ petition was filed, we had challenged, Lord, a building committee's order. A plan was sanctioned subject to, Lord, gifting of certain portion of the land. That is the subject matter of challenge in the earlier writ petition, which succeeded. But then, Lord, building committee, Lord, reinstated that decision again, despite the order of the High Court saying that that portion will stand deleted, that gifting part. Now, Lord, we challenge that order, but in the affidavit that corporation has filed to the writ petition, it appears that that order of the building committee has now been confirmed by the mayor in council. So, Lord, that we did not know when we filed the writ petition. If your lordship, Lord, kindly sees the amendment that is sought for, page 83. Or rather, my lord, page 75, if your lordships kindly come to. Paragraph 15A, 15B. This is, Lord, and then, Lord, please come to page 83. We are really challenging that mayor in council's decision.
Then why amendment? Why don't you file a fresh petition?
But, it is a subsequent-
because it is the approval.
I tell you, Lordship, when we filed the writ petition, this decision we had no knowledge because it was never communicated to us. This was communicated not only through the affidavit in opposition which they have filed. If I don't challenge, Lord, this
You
order,
challenge it, I'll give you leave to challenge it.
Lord, it is possible, Lord, in an amendment. This is a curable. curable defect.
The submissions are required to be amended, the prayers are required to be amended.
Prayer, only one prayer. Kindly see the prayer.
Whatever, because
Page
you'll be,
93. Kindly see the prayer. There is only one prayer.
yes,
We are
you'll
asking for
be
quashing of this.
quashing of that mayor in council's decision.
Page
That is
93.
the main issue, Radha, the approval of the mayor in council.
Lord, this
That's
was
the main issue.
This was not known to us. We proceeded. We were
That's right,
communicated.
but you file a composite
We
application.
were communicated with the building committee's decision.
I have followed, but then this is what is troubling the court is why go for an amendment when you
Because,
can
Lord,
file afresh.
It is a continuing cause of action. We have come to know about it, Lord, during the pendency of the writ petition by way of an affidavit which has come on record. So therefore, Lord, we are entitled to amend because, Lord, Order 6, Rule 17, Lord, permits this kind of an amendment to be brought in. Again, Lord, we go back in time. That is, if we file a fresh writ petition, again affidavit, again, Lord, we go back in time.
Yes, it has to be.
That is what we are trying to avoid. And this is absolutely a formal amendment. I mean, I don't think my learned friend will even deny that there is an existence of a decision by the mayor in council.
There may be an existence, but how you'll challenge it, whether by way of an amendment or by way of a fresh writ petition, is the question.
But this is not a fresh cause of action. This is not a continuing
What
cause of
will be
action.
your submission?
I'm submitting the finality takes place with the approval of the mayor in council. Because mayor in council, MBC's or decision is there until and unless the approval is comes from the mayor in council, that will not be valid. Therefore, he has to file a fresh application instead of making that amendment.
Lord,
Let
as
him
on the
make an
date,
application.
Would you like to file an opposition to
I'll
the?
file then if he likes.
Please come. An application for amendment has been filed by the petitioner. Stop. The said application is opposed by the learned advocate representing the corporation. Stop. Let affidavit in opposition be filed within a period of 4 weeks. Reply, if any, by 2 weeks
already
thereafter.
filed an affidavit. In the affidavit, he could have incorporated. This is already a part of his affidavit.
6 weeks.
Anyway.
Waiting for 6 weeks and filing a writ petition will be prior thereto.
Lord, that's not the end of the story. Then, Lord, the direction for filing affidavits again. So, Lord, another 12 weeks gone.
Yes. Don't call any other matter.
My next matter is mine, my lord. Small matter.
Yes.
Next matter is mine.
Yes. Small matter. Who is there? Who is your other side?
My lord, my learned friend is here. Like,
Is there any private respondent? Is there any private respondent?
no. There is, but they're not interested.
There is a private respondent, and the thing remains that private respondent is the in the expedition, he is the owner. That is a trust body. And trust body, when that is 412, that is notice was given. Nobody appear on behalf of the that is owner.
But what notice was given?
So who will actually, that is a remodel plan, or that is plan will be submitted for actually accommodating the tenant. And I am actually seeking another date for hearing is supposed to be given again on 20th April. Yours is kindly fixed a date after 20th April. Then I
20th of
Did
April.
you serve any notice? Whom did you serve?
My lord, 2-3 notice was served.
Let me see once. You give me
least-
the date so that I can incorporate in the order. Petitioner will get to know.
At least I don't know because I'm the
Please wait.
matters.
My lord,
the
here,
date.
here in this case, my lord, they the repeat.
Give me the date of hearing.
My lord, that my lord, that over the telephone, I actually believe the two hearing date was fixed. The last date was on, my lord, that is March, 20th March.
Well, the matter is pending.
20th March, the hearing was fixed. Your lordship can write it.
The matter is pending.
My lord,
Is it over on the 20th of March, or
No.
are you fixing further dates of hearing?
at the date of hearing, my lord, 20th March date was fixed for
When is
hearing.
the next date?
Next date is, my lord, 24th April.
Sure.
My lord, sure, my lord, they have.
And has the petitioner been intimated?
No.
My lord, that petitioner, my lord, the thing remains, we actually asked for the record of the inspection, that is the assessment department, who is the owner and who is the occupier. Under section 412A, everybody is supposed to give a hearing regarding the demolition of building and accommodation of the tenant. So everybody is not turned up. Again, we are fixing the hearing on 24th April, lordship. That is on what?
Issue is,
Come.
the issue is, my lord, that the building belongs to a trust, then given to lease to the
Learned advocate representing the corporation submits upon instruction that a date of hearing has been fixed by the
20 by the deputy, my lord, that is the hearing is giving by the deputy, my lord, executive engineer civil,
deputy executive engineer.
deputy, that is it. But I am giving that is
That's
election is there.
by such and such person
The deputy,
on 24th April 2024.
yes. So it is. My lord, executive engineer, civil building, borough 4 and 5.
Deputy na executive engineer, civil / building, borough 4 and 5. On 24th of April. And what about the notices to the private parties?
Private parties, my lord, regarding, my lord, if your lordship's, my lord, that is the private respondent 6.
The executive engineer is directed to serve notice upon all the necessary parties intimating the date of hearing. Stop. The fate of the hearing shall be made known to the court on the adjourned date list on 30th of April.
My lord, yes.
You get to know the date of the hearing. Please appear, and the others the corporation will intimate. No further matter.
right.
Lord, I'm for the respondent number 8, private respondent.
In this matter, my lord, I am one of the, my lord, owner of the flats. My lord, two owners of the flats. My lord, there are 4 persons. I have filed an application for addition of party, my lord. By registered deed of conveyance, my lord, might purchase the flat. Thereafter, my property has been mutated, and I am paying the property tax. My lord's view I have seen from the earlier order about the mutation. But be that as it may, that the person, the promoter, well, he is escaping his liability and he is not taking any steps. And my lord has directed on the last order to pay a sum of ₹1 crore deposit with the registrar.
I'm private respondent, complainant. Number 9 to 12, today I am appearing first time, file Bhogaladama in the department.
My application for addition of party is CAN 3.
Chief, upon my undertaking, the chief last occasion directed the promoter to deposit ₹1 crore before the land register.
But on the last day,
My
your
lord,
lordship,
I have also appearing by filing CAN 2 for addition of the party. I am also one of the purchaser, my lord.
Petitioner.
Who is for the petitioner?
He was to require to, my lord, deposit money.
Where is the petitioner? Petitioner has not come.
This is what we are afraid of,
The money has certainly not been paid.
my lord. But because, my lord, our situation is very precarious, my lord. In any way, we need to get some relief, my lord, from either of the forum. My lord, I am one of the purchasers, my lord.
the person who have added, my lord, in the application for addition of party are the, my lord, respondent number 9 to 12. They have given a specific undertaking before your lordship. Today, if my learned friend is appearing, my lord, I do not know whether he is appearing with an application for seeking addition of party or not.
Yes, my
But
lord. Yes,
Yes.
তুমি আসোনি তখন I have already made my
Look,
submission. My
but my
can
directorate should have not served
Yes,
copies to us.
yesterday only I have, my lord, I have affirmed it. I tried to serve, but I could not due to late hours. My lord, today, by course of the day, I'll serve them all the parties. I'll definitely serve. My lord, be that as it may, my lord, what I am seeking, my lord, at the present moment, under the considering the present scenario of the Honorable Supreme Court regarding the no tolerance regarding this aspect of unauthorized construction, my lord, I need some interference from this Honorable Court so that not only my client, let there be a precedence for all these type of cases that they should get some protection. Let the state also get some intervention. Let the corporation also come forward with a certain step what they have taken against those unscrupulous officers regarding a construction is being carried on. A ward office is there, ward officer is there.
And
They are
what
engaged-
steps do not have any Milord
What
responsibility
steps
prior
did
to
you take?
Purchasers are
What
not
steps
responsible
did
at all.
you take
Yes.
prior to purchasing the
prior to
property?
purchase, my deed,
Simple thing, Milord,
my
function
deed
plan.
clearly shows that the representation given that it's a multi-storied. My lord knows multi-storied means it's more than 2. G plus is more than.
Will you not check up the sanction plan?
My lord, I checked up, my lord. Thereafter, I have been told that for regularization, it has been deposited with the corporation so that it can be further fraud can be regularized.
And so,
My lord has asked me whether there is a portal.
yes,
I have asked them and it is already there.
it was existing.
It was existing, my lord. They could
So
have learned.
anybody can at the click of a button get to see whether
Anybody, my lord.
how many floors have been
Everything they
sanctioned
can
and
know.
everything is there.
Everything is there.
My lord, that is a matter of dispute whether at that relevant point of time that button was working or not.
Assuming
I
it
am
is
before
not
your
there,
lordship,
it
my
is
lord.
no.
I am not raising any voice. My point is
You-
very clear, my lord. I am
Listen.
before your lordship. I have every faith of this honorable court. My lord, get some protection for this type of
Try
person.
to understand a flat which costs say rupees 10, right? You purchase it for rupees 2.
No, not two.
Yes.
At that
Yes,
time,
that is being done.
at that time, what was the market rate? But that I'll come up with an affidavit to show
the court
that
is
is not an
not here to
underprice.
see.
This is not an undervalued
The
purchase.
court is simply not here to see whether you have paid the price or not. The court is to see whether the construction is legal or not.
My lord,
The moment I see the construction
that
is
is-
illegal, it has to be pulled down.
That is my submission. My lord gives some protection because
What
that
is the protection?
if my lord simply says that yes, the building is unauthorized, you vacate the premises, it will be demolished. But
Yes.
that is not the end of the job of this honorable court, my lord. My respectful submission is that
Very well,
my
you
lord,
stay
this
over
thing-
there,
No,
let the building
I am
come
not
down
going to.
and
I
you
am
go
not
to
going
heaven.
Stay over here, my lord.
Or you go to hell, nobody knows.
Get some, my lord, judicial precedence, my lord, so that this type of, my lord, all over India, my lord, all over West Bengal, this is going on, all over Garden Reach, Meteor Bridge, everything. My lord, this thing is going on. But some protection from this, my lord, from your lordship's end, so that some protection can get, my lord, these purchasers, and let there be a precedence for the future to come. But the petitioner, he was supposed to deposit
But then
1
what
crore, he
is
is not
to
present.
happen to the petitioner? Then the petitioner has to be
Deposit 1 crore.
brought before this
Yes,
court.
Milord, your lordship, direct Milord, the local
My
police
lord,
station.
my lord, my lord.
সৌমিত্র মুখার্জি Milord, the
Yes.
address is 8 অভয়পদ ব্যানার্জি লেন। No, no, অ্যাড্রেসটা অন্য তো, ওইখানে তো থাকে না
সেটা বলে
না, আপনার ব্যাটরার জুরিসডিকশনে পড়ছে না ওগুলো।
ঠিক আছে একটা মিনিট চলে আসে।
Please come.
And Milord, your lordship, kindly make it clear, Milord, the undertaking which was given on the last day.
Who is the advocate on record of the petitioner?
But he was
Probably he is already thrown.
Milord, the
He is
officially
already.
Orphan Gio, but
I
thereafter
am sure,
changed.
my lord. The way he was submitting before your lordship, I'm sure.
No, Milord, the initial advocate on record has changed. The last
Appointed,
occasion, the learned advocate who
appointed.
appeared, he has taken, Milord, no objection from the initial. So, Milord,
Where is the no objection?
I don't know whether
Please
that
check.
is on record.
কোথায় গেলে? প্রদীপ কোথায়? Please check whether there is any
Guho
no
was, Milord,
objection.
the original, Milord.
Original is Orpon Guho.
Yes.
Thereafter, has any no objection been filed on behalf of the petitioner?
রেকর্ড থেকে বয়ে যাবে
সৌমিত্র মুখার্জি the petitioner.
লাস্ট অর্ডারে কে দাঁড়িয়েছিল ভাই?
Debraj Mollik, the advocate on record whose name is recorded in the earlier order.
Sorry, my lord. I am for the
Yes.
petitioner, my lord. I beg to
He's
excuse,
already
my lord.
come
I was stuck in some other call. I'm extremely sorry, my lord. Is the my lord, I've been, my lord, I'm conscious about the order passed by your lordship on previous occasion. And I'm equally conscious about the fate of other flat owners as well. So the first question I put to my client is, what about the, my lord, the structural stability of this building? Because I understand, my lord, they also require some
No
time.
understanding. On the last
Yes,
date,
I'm coming
there
to
was
that
a
point.
direction for
Yes,
payment
I'm
of
coming to
one.
that point.
Where is that money?
Kindly allow me, my lord, to make my submission.
No.
So the first point I asked, my lord, what about the
You
fate?
are, whether there is structural stability or not, the court is not here to see that.
Regarding that issue, my lord.
No, don't, you say where is
Well,
the
as
money?
far as that money is concerned, my lord, what I have understood from the, my lord, the purport of the order, as well as, my lord, the transaction made by my client with other flat owner. That amount, my lord, is coming around 45 lakhs. I have calculated.
Where is the 1 crore
Around
of
45. It is
rupees?
not 1 crore, my lord. This is my first, my lord, first submission. Out of 1 crore, my lord, the money at all he has received, my lord, is 45 lakhs. And second option is, my lord, that I have instruction, my lord, to try my luck, my lord, before the higher crore. So for the 1 crore part is concerned. And as far the,
I will immediately direct your client to be arrested.
my lord, that is, my lord,
Immediately to be arrested
for the 1
and
crore
to
is,
be put under prison.
my lord, 1 crore, my lord, he is not in a position because he has not received that money, my lord. Kindly appreciate this
Let
point.
him go to jail,
He has
and
not
from
received
there
that
let him
money.
fight the case.
My lord, he has not, firstly, my lord, he has not received that money, and secondly, my lord, to demonstrate all these facts, my lord, kindly allow me either to file a CAN application or give me some time to produce those
No.
reports. How much amount, my lord, that is a, my lord, material subject to correction, my lord. So that is a material consideration, my lord, how much money he has received. Even if, my lord, prima facie, I hold myself liable, then also, my lord, perhaps I'm not entitled or liable to make more payment than I have received. So for the merit of the
What
case,
about the safety and
Safety, yes.
security concern of so many
that
people?
is the thing, my lord. That is the first point. At the very outset, I tried to convince your lordship about the stability part is
Do
concerned.
not
Kindly allow
convince me.
because they are not
There
they are not
is
at all
no
unsafe.
sanction, irrespective of the fact whether you have a stability certificate or not.
Yes,
As
my
you
lord.
do not have a sanction,
Yes,
you
that
do not have.
sanction is under challenge before your lordship.
It cannot be
My lord, the sanction
permitted
is,
to stay.
my lord, the rather the refusal to sanction, my lord, my revised building plan is under challenge before your lordship, and that has not been finally
Absolutely false
adjudicated.
statement, Lord. What
How
is
many-
actually saying?
That is has not been
How
finally
many floors were sanctioned?
My
The
lord,
ground floor and partly first floor.
my lord, ground
And
three
how
plus
many have been constructed?
My lord,
3 plus 4.
I am told, my lord,
Four.
three plus four.
5 stories.
And the revised building plan is already submitted, my lord. On
That has been
with the-
cancelled
Yes,
by
my
the
lord,
order of this honorable court.
that has been, my lord, challenge before your
আসুন তো দেখি।
my lord,
Please
kindly
come.
allow me to, my lord, to demonstrate all these facts by way of filing a supplementary affidavit.
Your client is a developer, promoter developer. And
Kindly allow
how
me to
many other constructions is he making?
My lord, that I do not know, my
You
lord.
do not
That
know.
I am not aware of. But this building is concerned, my lord, I have certain documents to show that none of the flat owners at present are unsafe. So for the safety is concerned, my lord.
The petitioner has not deposited the sum of rupees 1 crore as was directed. As was directed, video order dated 20th of March, 20 March 2024. Stop. Learned advocate for the petitioner submits that the petitioner has received not more than rupees 45 lakh in total from the flat owners on account of sale of the subject flats. Stop paragraph. It has been submitted that the petitioner would not be liable to pay more than what he has received from the purchasers of the flats. Stop paragraph. Be it recorded that plan was obtained for raising construction of a ground and partly first floor at the subject premises. Stop. The petitioner went on to raise a G plus 4-storied building Stop. Next. As admittedly the constructions made in the second, third, and the fourth floor are illegal and unauthorized. Accordingly, the Howrah Municipal Corporation is directed to immediately disconnect the water supply of the aforesaid flats. Stop. Next. The Howrah Municipal Corporation is further directed not to allow the petitioner to apply for not to accept any type of application from the petitioner seeking sanction of any building plan, and the petitioner shall be restrained from constructing any construction within the jurisdiction of the Howrah Municipal Corporation. Stop. The electricity provider of the flats in the subject structure, it must be CESC Limited. It must be CESC Limited.
Yes, Milord. Yes.
That is CESC Limited is directed to forthwith disconnect the electric supply connection to the second, third, and fourth floors of the subject structure. Stop. Next. The corporation is directed to lodge complaint against the petitioner before the police. And the police shall take steps against the petitioner. Stop. Next. The inhabitants and the occupiers of the flats constructed unauthorizedly have filed application for addition of party. Stop. How many are there?
I am representing two flats, 4 persons.
4.
I am representing 1 flat, 2 purchases.
I am for 4.
No, who have already
We have
been
already added. Respondent number 93.
Very well. Achha. Application for addition of party. Let the applicants be added as parties in the instant writ proceeding. Stop. Next. How much will you pay now? 45, 50?
I have no instruction. They have received the payment. Kindly allow me to.
Who has received the payment?
No, the promoter. The promoter from the consideration money that I put this question and I'm being answered that this much of amount he has received, my lord. My lord, apart from that, kindly appreciate this thing.
I am not appreciating anything. How much are you paying now?
That instruction I have to take from my client, my lord.
Kindly sold out his
I'll direct the police to bring him here.
Only one.
Or will he come at 2 o'clock?
The instruction I can always take, my lord, even going outside and making a call, my lord. That is one thing. The second thing, my lord, the rejection order that has been challenged before.
Rejection will be seen later on. How much are you paying?
My lord,
how much are you paying?
I have to, my lord, take instruction, my lord. Kindly allow me to, my lord, come back after few minutes. Then
one submission, my lord. One submission. My lord, the address given by the petitioner as his own address, it is his own personal property.
Let that
be attached. Otherwise, this
his father's property, his father
this
died,
unscrupulous
Milord, has
person,
taken
my lord,
instruction. He is the only son.
But the conduct of the petitioner, my lord, deserves the attachment of this property.
That would be a travesty of justice.
No, my lord, certainly not.
Come at 2 o'clock.
My lord.
It is shesh korben na.
My lord will consider my submission.
2 o'clock.
My lord will consider
Much money to be deposited.
I'm deeply obliged, my lord.
একটা ওই হ্যাঁ টাইপ করে রেখে দিন, ওটা দেখছি কি করে। আচ্ছা, আর এই অ্যাডভোকেট অন রেকর্ডের নামটা কিন্তু চেঞ্জ করতে হবে, লিস্টে অ্যাডভোকেট অন রেকর্ডের নামটা চেঞ্জ করতে হবে। ও তো যখন নো অবজেকশন ফাইল করে দিয়েছে তখন তো এটা চেঞ্জ হয়ে যাওয়া উচিত।
My lord, item number 2, I'm not pressing the application, my lord.
Yes,
Petitioner does
now
not want
comes,
to.
my lord. We have been harassed numerous times. For unauthorized construction, they have filed a writ petition for unauthorized construction, alleging there is unauthorized construction, and it is really an unauthorized construction, my lord. He was a tenant there, he or she, I think. Tenant there, my lord. Thereafter,
Where is your written instruction? Let me see.
entire construction is
I have
unauthorized.
followed it.
We have passed a reason order and found entire construction is without sanction.
Demolish it.
Right.
Don't wait as to whether he
Right.
withdraws or not.
These things are harassing us, and thereafter they are
Please come.
contacting each other, and they have
The petitioner filed the instant writ petition alleging illegal and unauthorized construction. T3. Check this thing. In this case, did the petitioner allege unauthorized construction, or is he challenging the order passed for demolition?
petitioner alleged unauthorized construction.
Petitioner alleges.
My lord.
The petitioner alleges
Construction is unauthorized.
illegal and unauthorized construction at is there any premises number or what?
Thanks.
Petitioner এই মামলা করেছে challenging unauthorized construction.
Salbagan Road, Benachiti, Durgapur 30. That is sufficient. Twenty-seven
At the
Vivekananda
behest of the private respondent.
27 Vivekananda Puri.
At 27 Vivekananda Road. Where do I get that address?
And I am just showing. And that is at page 45, not 27. Will be annexure fee for page 45, my lord. Plot number 324, Salbagan Road, Penachiti, Durgapur 30.
Then just now you said the name of
No. But yes, G+1 story commercial. 47. I'm sorry, my lord. 47 at the last but previous paragraph, my lord. Residential building over plot number 324, jail number 67.
plot number.
Muja Benachiti,
Plot number 324, jail number 67, Mouja Benachiti,
Durgapur 13 district.
within the
district
jurisdiction of the Durgapur Municipal
Municipal
Corporation. Stop. Next.
and Salbagan Road number 1, my lord.
Where is that?
Next line. Over
In
one and
front of.
in front of Salbagan Road of number 1.
আচ্ছা ওখানে লিখে দেবেন in front
Just
of
beside.
front side of শালবাগান road number 1. 47। আচ্ছা 48ও পেয়ে যেতে পারেন। The presently the petitioner has given a written communication to his learned advocate disclosing his intention not to proceed with the writ petition any further. Stop paragraph. Learned advocate representing the Durgapur Municipal Corporation submits upon instruction that
Brother is also not the advocate record.
it has been addressed to the on record. Acha. Ki bollam? Appear for the corporation instruction that the construction in question is indeed an illegal construction. Stop paragraph. As the petitioner does not intend to proceed with the writ petition, accordingly, the same stands dismissed as not pressed. Stop. It is made clear that dismissal of the writ petition
My lord.
will not stand in the way of the Durgapur Municipal Corporation to initiate appropriate proceeding to deal with the unauthorized construction in accordance with law.
Grateful.
The written communication made by the petitioner to the learned advocate on record be retained with the records.
Lord, I appear for the petitioner.
I am for the private respondent number 10.
Illegal construction of a 5-story building in ward number 35, my lord, of Bidhan Nagar. Lord, on the last occasion, my lord may recollect, Lord, Justice Gangopadhyay's order was placed before your lordships, wherein his lordship, Lord, his lordship's 2 orders were placed before my lord. One is the order dated 16th October, another is the order dated 17th October. 16th October order, his lordship directed it has to be demolished immediately. And 17th October, his lordship was of the view that since the councillor who was present in court and lot of residents of that building who they came, that the municipality should think about some solution. Now, my lord, in the name of finding out that solution, the municipality has filed a report before my lord. My lord may have a look at that report.
Yes.
Lord, I am not placing the first 2 paragraphs. Kindly take the 3rd paragraph on the note. On that, my lord has kindly got it. On that note, the committee is tasked to find out a solution to save the occupiers of the building in question who are very poor and living almost a subhuman life. These occupiers have been duped either by co-sharers, owners, or by developers enticing them to buy property for a better living, or unaware of the myriad of laws, these occupiers have purchased flats, sans the knowledge of law and or the requirement thereunder. Due diligence may not be in their dictionary when day-to-day survival is a challenge to most. These persons have wrung their life savings to buy a property to have and give a decent way of living to themselves and their families. In the teeth of such situation, demolition has not been discussed on a humanitarian ground. Now, kindly mark this: demolition has not been discussed on a humanitarian ground, as the same will leave these hapless people under the open sky. A sympathetic approach has been discussed with right earnest. Lord, I will just pause here for a moment. I'll remind your lordships for your lordship's reconnection. Deepak Mukherjee, there, my lord, I was addressing for the developer. We took this point. Supreme Court.
Who is the developer over here? Is the developer a party?
Yes, the party they are
Right and
appearing.
Respondent number 8 and
Number one.
Who is the developer?
Lord, they have
I
been
am for
appearing.
respondent number 9, my lord.
Anybody representing?
Lordship, I am for respondent number 9, my lord. Two developers, my lord. Respondent number 8 and 9, my lord. I am
8 and 9.
representing 9, my lord.
You are one of the developers.
One of the developers.
And you admit that the construction is illegal.
Lordship, the difficulty is that, your lordship.
No difficulty. Tell me whether the construction is legal or not.
Lordship, although they have not obtained the, your lordship, the sanction plan, but
How many floors are there?
G+4.
G+4.
And did you obtain sanction for any of the floors?
Your lordship, subsequently we have approached the authority, your lordship.
Not subsequently. Law requires a sanction to come first.
Lordship.
Did you obtain the sanction or not?
No, your lordship.
You did not obtain the sanction. And you went on to raise the construction. That is the thing.
Your lordship, the building has been constructed in that way that it is.
Listen, the court is not here to see as to whether you have the expertise to raise construction without a sanction plan. The court is here to ensure that unauthorized construction is not made. And if it is made, that should be raised to the ground. Where is your client?
He is not present, your lordship.
He is present?
He does not.
He is not present. Where is he?
Lordship, may I?
I'll send him to custody immediately.
He should.
My lord, considering the, your lordship, considering the.
I'll see what is to be considered later on. Where is he?
Deepak Mukherjee order.
Lord, kindly, I will call him, your lordship, kindly feels better.
There is no requirement of calling him. I'll send the police to get hold of him and put him in the prison.
Your lordship, he is also the unfortunate, your lordship, person, your lordship, because your lordship.
Unfortunate. How much money has he collected from these people?
My lord, kindly, my lord, kindly.
How much money has he collected?
My lord, I have to take instruction, your lordship.
What are you here for? To support an illegal act?
Lordship, one report has been, your lordship, submitted by the municipal authority, your lordship.
Let the authority submit any type of report. It is for the court whether to accept that report or not.
Your lordship, considering the situation of the inhabitant, your lordship.
Which inhabitant?
Those who are residing in that building.
Who has sold those flats? Who is responsible for such type of condition?
Lordship, the co-owners as well as the private respondents here in your lordship.
And you are the developer?
The petitioner is one of the co-owner, your lordship.
Very well.
Of that building, your lordship.
Let the petitioner where she is or he is. Why will an illegal construction be made? How much money have you earned from this construction?
My lord, the difficulty is that, my lord, may I respectfully submit, your lordship, that everything has been done, your lordship, right from the beginning, your lordship. The petitioner is one of the co-owner of the land, your lordship. Kindly consider, your lordship. Now,
what is to be considered? The petitioner, being the co-owner of the land, tells you to do something illegal and you go and do it. And then you sell it and you collect money.
Lord, the inhabitant of that building they are also in worse position, your lordship. Kindly consider, your lordship, the report, your lordship.
As of date, my instruction is that,
Let him remain
as
there.
of now,
No
not even
difficulty.
50% has been collected from the inhabitant, your lordship.
50% money has been collected. What about the balance 50%?
They have not paid, your lordship.
Not paid.
As of-
Where is the 50%? Are you entitled to receive any money?
No, your lordship.
And you say 50% has been
Lordship,
paid?
that money has been already invested in construction of that building, your lordship.
Construction? Who permitted you to make construction? You go and throw your money everywhere. Who is bothered?
তোমার মক্কেল তো কোর্টে আছে।
আমার মক্কেল?
Yes, he's in
না
court.
না, respondent number 8.
But one of the developer is in court.
Respondent number 9 is not here.
No.
My client.
Do you have that book with you? The Promoters and Developers Act.
Promoters and developers.
There is a provision for immediate arrest.
Lord,
And it's
I will, Anna. Lord, I'll
cognizable and non-bailable.
Yes, Lord, I'll place
provision.
that. Till such time, Lord, may I beseech your lordship to consider one order of the division bench with regard to the same ward. Kindly have a look at this and kindly see how the division bench.
The pill matter.
Yes, kindly see how the division bench has deprecated the municipal authorities and also warned them that there should be proceeding initiated on the Prevention of Corruption Act against the municipal officers. Kindly allow me to place this. I'm getting that act.
But then the officers are no way involved in this matter.
But I will
because
show
there
you.
is no
I will
sanction.
show your lordship how they are involved. একবার এটা প্রদীপ এটা দাও তো একটু। I'll show your lordship. I'm carrying other order. বইটা আনো। But kindly allow me to place this and one order of Justice Tirthankar Ghosh. I was submitting on the last day. Lord, this is concerning. My lord will take me, Lord, internal page 2.
Yes.
Para 4 onwards, I'll just place. It is the candid admission of the municipal commissioner that the writ petition pertains to the area of Santinagar. Lord, this is also Santinagar, this building. Noabhanga and Novopolli in ward number 35 and 36. And as per the record of the Bidhannagar Municipal Corporation, the plots of these areas are categorized as rehabilitation plots. The Department of Urban Development and Municipal Affairs is the custodian of these plots and has sole authority over the allotment of such plots when plots are allotted under a particular scheme of the government, particularly as a rehabilitation measure. We do not see that there is any authority in the allottee to change the purpose of allotment of the user or to conglomerate the allotted plots and get into any activity which will be counterproductive for the very sound concept of rehabilitation and in violation of the guiding laws. The government lands are primarily public lands. They are not to be doled out as a matter of gracious gift by the authorities empowered to grant allotment to the plots for rehabilitation. The purpose of allocation cannot be sequestered to convert these areas into such sites which could be put to use for the commercial purpose of building of real estate sector, even if the structures which may be put up there ultimately shown to be residential unit. It is also submission of the municipal commissioner through his affidavit that no records are available with Bidhannagar municipality regarding possession and allotment of the plots which are the subject matter of the writ petition. He further proceeds to say that the 2 plot numbers specifically referred to in proceeding number so and so seems to have no sanction order or approval of the building plan. Obviously, therefore, no building permit is there for those plots. The municipal commissioner appears to have passed on the problem to the state. Taking the contents of the affidavit of the commissioner of Bidhannagar and the report of the on behalf of the state, we are hereby order that all further construction activities. This is in March 2021. The building has come up after this building. All further construction activities in any of the plots in the area of Santinagar, Noabhanga, and Novopolli in ward 35-36 shall stand injuncted by the force of this order unless in relation to any plot the Commissioner of Bidhannagar Corporation issues an order recording that the construction activity in such plot is being carried on the basis of approved building plan, permit or otherwise. The Commissioner of Bidhannagar Municipal Corporation shall forthwith create a task force to make physical inspection of the entire area of ward number 35-36 of Bidhannagar and issue stop memos of demolition notices as are required in terms of the statutory provisions, and following due procedure, final decision on them shall be taken by the competent authority under those laws in conformity with the laws, and after hearing the necessary parties, stop memos do not call for prior notice. Issuance of demolition notice after holding that particular construction is illegal also do not require prior notice. We are stating all this aforesaid here because it appears to us that the official of Bidhannagar, including commissioner, do not appear to be sufficiently conversant with the laws governing the activity of municipal corporation. We make this polite statement, also inviting the attention of those officials to the provisions of Prevention of Corruption Act, which contains certain preemptive measure situations, and to other provisions, including under the Indian Penal Code, to proceed against the entire public servant, erring public servants who pave way for private individuals or institutions to make gain in the violation of law. Now, kindly pause here for a moment. 2021, Bidhannagar Corporation was directed to make a task force. They themselves said no plan is there for Shantinagar. They were aware that all constructions are stopped. Lord, the municipality should answer you before your lordships. What were these officers, including the commissioner, doing from March 21 till Lord 2024? How did this 5-story building come up in open daylight? And proceedings under the Prevention of Corruption Act should be initiated against these officers. Lord, every time these officers cannot get away by saying that we have formed 20 men's site, we have formed 50 men site. Lord, apropos to this, I will now show your lordships Justice Tirthankar's Ghosh's order in a proceeding. দেখাচ্ছি ওকে একটা কপি দিতে চিন্টুকে Lord, kindly take Lord, it's not paginated. Kindly take Justice Ghosh's order. It will be Lord in the middle of that compilation. 5th page or 6th page. Sierra 3646.
Yes.
Lord, what happened? I tell you, Lord, says Lord, the municipal building tribunal directed initiation of departmental proceeding against officer in charge of Maniktola police station. He came up in a CRR before Justice Ghosh. Justice Ghosh, Lord, formulated. Lord, kindly take Lord internal page 3 of the order.
Yes.
Pursuant to the directions passed by this court on 4th October 21, a standard of procedure has been prepared in consultation with the police authorities. Lord, this was also done as per Justice Ghosh's order. Represented by Deputy Commissioner of Police, Cybercrime, Lalbazar, Kolkata, and also the Swanso building, Kolkata Corporation, and both the government departments have agreed amongst themselves to adhere on an information of an unauthorized construction by a private person before officer in charge of a police station. The concerned officer in charge, either by himself or by sub-inspector of police who has been endorsed with a complaint, without any delay, will write to the executive engineer civil KMC of local borough having jurisdiction to let the police know if the construction alleged is unauthorized or not, as mentioned in section so and so. But here, when someone lodges complaint to the police, he will immediately forward. Then 2, KMC, after receipt of the information mentioned in serial 1, will inspect the said construction site without delay, submit a report with the police station within 7 days, working days, stating the construction is authorized or not. On getting report from KMC authorities that said construction is unauthorized, the officer in charge will direct sub-inspector of police station to register a case under provisions of KMC Act, treating the information along with KMC report as FIR. If the report of KMC authority does not reveal any unauthorized construction, then the information may be filed and diarized, and the private information should be informed as 7 working days. In view of the settled procedure to be adopted, and the fact that the police authorities are not the proper authorities to address the issue of unauthorized construction, which is within the domain of expert of the field, and it is to be decided by the engineers associated with the municipal authority, I am of the opinion that the police authority should not be saddled in the midst of a litigation for inaction for which they are not expert to decide. Henceforth, if the procedure laid down above are not followed, the concerned officer would be held responsible for dereliction of duty. So, Lord, I am trying to impress upon your lordship is that the division man says that Bidhannagar officers are completely, Lord, ignorant of law. They're running the municipality. There should be proceeding initiated under the Prevention of Corruption Act. A polite, Lord, observation was made by the division bench that you are paving way for the promoters to make unauthorized constructions. On open daylight, buildings are coming up, people are getting in, and then people will start crying that we are helpless, we are hapless, we don't have money, we have invested, please allow us to stay. Lord, this cannot be, Lord, entertained. Number 1. Number 2, the police authorities also cannot shy away from their duty. Lord, this I beseech your lordship, Lord, this was implemented for KMC. Your lordship, my lord, having the jurisdiction under Group 5, kindly implement this scheme for all municipalities in the state.
What to be implemented? It is only direction upon the police.
If the police doesn't do it, Lord, it is a combination of both. What is happening is, when we lodge a complaint, police remain inactive. When we lodge a complaint to the corporation remains inactive. Both of them are not active. We are coming to court. You will also directing them to do it. Again, it is not being done. We are coming for contempt. By the time the building comes up, but the speed of the construction increases.
No, it's all right. But then what is recorded over here is immediately when a complaint is lodged, the corporation, the police is going to intimate to the corporation.
Internal page 4, the last line. Henceforth, if the procedure laid down are not followed, the concerned officer would be held responsible for dereliction of duty.
The procedure means an information or a complaint is lodged.
I inform to the police. Police forward it to the municipality. Within 7 days, municipality will make an inspection.
Right.
So if it is not done by any of the officers, the police or the municipality, they will be held liable for proceedings for dereliction of duty. Departmental proceedings should be initiated against them. If that threat is there, if that is your lordship judicial observation, Lord, over all municipalities, then Lord, there will be a
Something more
streamlined
than
process.
this is required.
Lord,
only this much is not
Lord,
enough.
this is my submission. At
I
least we can start with this.
I can understand the agony of the complainant as well as the persons who have purchased
Now the
flats.
second limb of thing, Lord kindly considers. Today, the residents are saying that we have invested. Municipality says that we will, although there is no plan, we will now check the structural stability. So, Lord, if this proposition is held.
No, this proposition was came in only after the court intervened.
Order of 17th October.
Because
I knew that they will try to take shelter. That's an interim order.
Your lordship knows in several matters.
Corporation directed demolition.
There was no direction for the corporation in this matter.
Corporation went for demolition in
Went
terms of
for demolition.
earlier order of
Corporation did not do anything. When we came to court, Justice Ganguly directed, then the corporation went there. Gangopadhyay and Bandyopadhyay, sorry, they are very touchy on this.
No. How can I misspell a judge's name? Right? It's not about being.
Justice Gangopadhyay, you are being touchy about Banerjee and Bandyopadhyay. So, Justice Gangopadhyay on 16th October directed that you go and demolish. Then only municipality went there. And my representation,
what was the writ petitioner's case that no steps is being taken?
Lord, kindly take page 33 of the writ petition.
33, yes.
On 30th of March 2023, I wrote to the commissioner.
This is the complaint.
With a copy to the police, page 34. Lord, they have received it, Lord, on 6th of April, page 37.
Yes.
So from 6th of April 23 till
steps were
16th of October 23, when Justice Gangopadhyay passed the order, municipality was not absolutely ignorant about it.
And when you lodged the complaint,
yes,
how big was the structure?
But I'll just place it.
G+4.
Not kindly see
Where
page
it can-
34.
Then
Page
without
34 top.
being raised by this-
Measuring about more than 3 katas by virtue of the said agreement, promoters were asked to develop G+4 story within 36 months in accordance with the sanction plan granted. The very recently it has come to my knowledge that without any proper sanction, the building has been raised by the said promoter, and the furthermore presently promoters are raising an additional floor also over the G+4 story. After coming to know the above fact, the undersigned herein protested against the illegal activity. But kindly inquire from the commissioner from 6th of April what they did. On 7th, 8th, 10th, 15th, 20th, whether they went and inspect. No. Lord, this is the dereliction of duty. There lies, Lord, the problem. In one case, your lordship will have to send him to prison. Then they will be strict. And Lord, in Deepak Mukherjee, Lord, I was appearing for the developer. I had to pay each and every one. The building was put, brought down to the sands. Lord, I have to pay entire amount. Justice Bosak freezed all my bank accounts. All my properties were taken from me. All the original deeds are still in the custody of this court. The developer, the respondent number 8 is here, 9 is here. Their bank accounts should be immediately freezed. All their properties should be sequestrated. Your lordship will take custody of the properties. And Lord, the persons who are now taking shelter by saying that we have purchased Lord, they ought to have not exercised due diligence. Well, municipality ought to have not put up board there that this is an illegal construction. And Lord, in Justice Gangopadhyay's order of 17th October, if my Lord sees, my learned friend says that he is not aware of the money that is taken. Can he take the 17th October order?
20 lakh of rupees and 8
Not
lakh
only
of
that,
rupees.
not only that, para 1,
3 lakh
para 1
23,000.
from Manoj Shaw, 5
Those
lakhs.
figures have been mentioned. I can see here.
Yes, the figures have been mentioned.
Yes.
So he is completely aware up to what money he has taken.
Yes, yes, yes. I can see that.
He cannot today say that I have not taken any money or I don't know what is the money taken. And 16th October order, they have admitted. But kindly take 16th October order.
Yes.
First line, it has been admitted by respondent number 8 and 9, the promoters builders the building, they do not have any sanction plan. My Lord, even yesterday, I tell your Lordship, my Lord, I was moving an appeal before the division bench against your Lordship's order. My Lord, there were 18 occupants in the building. My Lord, the division bench said that the time has come when we should send the message very loudly. Whoever is the occupant, the building has to be demolished. And the demolition is going on day-to-day basis without even considering the aspect of rehabilitation. Justice Gangopadhyay's order is contrary to Deepak Mukherjee, contrary to Esa Ekta, contrary to Supertech. It's a per incuriam, number one. Number two, it's an interim order, which will have no bearing on the merit of the case at the final adjudication. Corporation is trying to take shelter under that order.
No, not at all.
Possibly not.
Not at all.
If they are not taking shelter, let them demolish.
See, what I have produced your Lordship, the first page, third paragraph makes it loud and clear. We are not even trying to make an interpretation out of the provision.
In fact, 16th October order clearly records that no building without any sanction plan should be allowed to remain on any plot of land. And all inhabitants should be removed forthwith.
That's the order. Lord, there was an agitation. Justice Gangopadhyay directed Lord, the Deputy Solicitor General to appear on the next day so that Lord, the paramilitary forces could be deployed and it could be demolished. Lord,
these submissions should not be made, Malad. It is not written anywhere.
No, it is written here.
Told that Mr. Bandyopadhyay was there in court and this was the observation.
It is written, page 3 of the order. Mr. Bilodal Bhattacharya's name I see is written 16th of October.
See, Malad, nobody has been able to give correct number of flat owners.
17th of October, page 3.
No. Me recorded.
Page 5, I see, if necessary, in future, I may have to obtain the help of CRPF for demolition of the building.
I'm not
Everything is
saying
recorded.
anything wrong. I'm not saying anything
It is
wrong.
recorded in the order.
Yes.
The IC Vidhannagar police station was present in court.
Yes.
And because of the festive season, the police forces
5 top, first line.
were busy.
If necessary, further, I may have to obtain the help of central paramilitary forces.
Everything is recorded.
Lord, I only say, Lord,
Now,
that
Mr. Bandyopadhyay, the report that you have placed on the last day, after the Garden Reach incident, we have to be a bit more strict.
I repeat it, Malad, at the cost of repetition, Malad, that on 16 there was a direction to proceed with the demolition. We proceeded. There was a resistance. On 17 we came back, we informed, and it was, Malad, not taken in the we were not spared. That is what I'll say. That, and we had to answer the question that why we could not carry out. The police authorities, Mr. Mukherjee was representing them, that why they could not give appropriate assistance also. Those questions were answered. And thereafter, whatever transpired, is in the order of 17th October. But pursuant to the 17th October, it may be a futile exercise, may not be a futile exercise, we have conducted, if not, your Lordship, every court has its own way of operation. And we have seen officers being asked to appear at 2 p.m., 3 p.m., 4 p.m. or appear before other authorities at 3 p.m., 4 p.m., 5 p.m. Whichever way it might be, all types of directions for compliance are not same. So we have complied with the order.
We have placed the order before your lordship. Only thing, it was directed to be made in a report. We have given the entire.
Very well, I have
minute.
seen that.
What, my lord, is being submitted by my learned friend, my lord, the matter with regard to Suman Das as creation of task force, etc., my lord, we have already shown compliance before the PIL bench, my lord, that we have formed the task force, and I also made the submission on the last occasion that in compliance of those orders, we have already made task forces.
Is the task force functional?
Functional.
What
Apart-
were your task force? What was your task force doing after receiving the complaint at page 33? Please tell me.
My lord, this probably, my lord, was not considered by the time the writ petition was considered by the honorable court, my lord.
So what were they doing from 30th of March till the writ petition was filed in May and order was passed in October?
My lord, with regard to these two wards, my lord.
These two?
These two wards, 35, 36, my lord. Almost, my lord, 330. My lord,
Unauthorized construction.
plots were considered, their documents were asked for, and this entire exercise was taken up from, my lord, April, May, June, July. Some produced, some could not produce, majority could not produce. My lord, there were three sections, one that could produce, one who could produce, but there were constructions beyond what they could produce, and there was a major chunk who could not produce anything. Demolition orders have been passed in those matters, my lord. So it is not that just because for this building no stop work notice was issued, that the task force was not acting at all. The task force was acting, my lord, probably with regard to this building.
Selectively.
With regard to this complaint, probably by the time the writ petition was taken up, my lord, no steps were taken up by the authorities. I cannot better that case from the bar. But, my lord, as far as any and all of the orders of the PIL bench is concerned, but we have already shown compliance on a day-to-day basis.
No, listen, when matters are before court, your officers become a bit vigilant. Now, where complaints are lodged, but writ petitions or any suit or any legal proceeding is yet to be taken, the officers don't budge, right? Now, if the construction could have been restricted immediately upon getting notice, then things would not have gone to such a pass.
This complaint, as petitioner says, my lord, this vigilant petitioner made the complaint on April 2023. Your lordships will find from the initial paragraphs of the order of 17th of October that these flats were purchased sometime in 2022. So, my lord, all this was under the nose of the petitioner also it was happening, and as I submitted, the petitioner's daughter is living in the same building. So it is not that this vigilant petitioner did not have knowledge of it. Only when there was a fallout between the petitioner and the other person, she decided that she will lodge a complaint, and she has all the right to do it. So, my lord, these persons, when they purchased by registered or unregistered deed, whatever, the flat was existing because the flat is described in the schedules. So before the complaint reached us, my lord, these things had already happened. They immediately, my lord, when it was directed, my lord, we have taken steps, my lord. If I may put it in this way, my lord, your lordship, my lord, I bow down to, my lord, the selection of word by your lordship that officers become vigilant when a matter is before the court, my lord. If I may place it this way, my lord, when the matter is before the court, the officers try to prioritize it, my lord, for the majesty of the honorable court, my lord. But there may be 10 files on the table, my lord, but 5 having been litigated and before your lordship, my lord, they are given priority. But it is not that they are not vigilant about the others or they want to pick and choose about it.
Did they do anything prior to the court's order being passed?
With regard to this building, as I say, my lord, in the 6 months, it was not done. But, my lord, in that area, for other buildings, my lord, day-to-day hearings were being taken on a day. Almost 5, 6 to 10 hearings were being taken because 330 reasoned orders have been passed. Not one-line orders, reasoned orders running to 1 page, 2 pages, my lord. All reasoned orders, my lord, because they were also subject to challenge. And some were in fact challenged before the PIL bench, which also we defended. We are not selective about it. That we are passing orders, that let it be set aside, we don't care. We are defending those orders also.
Very well. In that case, let the provisions of the Prevention of Corruption Act be initiated against the officers of the corporation.
In this case, we have to added respondent.
Added respondent is the flat owners.
The petitioner himself entitled the developer agreement in 2019. We purchased flat and
whatever is the internal dispute between you and the petitioner, you and the developer, whoever, go and sue.
They are already entered the agreement of the agreement of sale, and they are already entered into the premises in 2022.
Very well. Construction is illegal. no order of injunction can be made applicable in respect of any constructions that is illegal, which do not have a sanction. The construction could not have come up at all, right?
এখানে ফাইলে নেই কেন সব মোবাইলে ফাইলটা দেখে তো আমি সাবমিশন করছি Malad, I'll just Malad, at the cost of interruption, Malad, one document was not there in the file, Malad. I'll get it printed immediately. On 19th of September, before the orders, on 18th of September, Malad, on the basis of the complaint, we have given a notice of inspection to the occupier that we'll come and inspect the property. Date, and the date of inspection is 19th of September. So that
Yes, it was inspected.
It was inspected on 19th
And it was found that the construction, entire construction is illegal.
Malad, we found that inspection is done on 15th of September at 4:30 p.m. at so and so. Now it is a G+4 storage building, ground floor, a number of shops, no roadside rest portion consists of 3 number of flats. Second floor consists of 4 number of flats. Interior work is going on in most of the flats. Any copy of the sanction plan could not be produced at the time of inspection. But this is the
What steps did you your
only on 19th of September, Malad.
Right.
Malad, thereafter, Malad, on 16th October, the matter came up before the Honorable Court.
So 1 month time you got in between after noticing that it is an absolute illegal construction
It
without
would have
any
been done,
sanction.
Malad. What I'm trying to submit,
It
Malad,
was not
it is
done.
not a case the way the petitioner is trying to take a case that we wanted to save the building and we were not vigilant about the building, Malad. We
Without
received the
going into
complaint.
that, fact
Yes.
remains that nothing was done.
Not done, Malad. Now, if it's the case of Malad invoking the Prevention of Corruption Act, Malad, humbly, Malad, I'm making this submission. The petitioner, number 1, has not made out the case. Number 2, for invoking Malad Prevention of Corruption Act.
Oh, because of the division bench's order?
Malad, division bench says that it can be invoked, but it does not say, or it cannot, in fact, it cannot give a go by to the requirements of the statute. The requirements of the statute will require the petitioner to plead a case of illegal gratification, and they will have to make out the case that who illegally gratified which officer. That is the requirement of the Prevention of Corruption Act. My learned friend knows that. What the division bench says is that this is a possibility and it can be invoked. The petitioner, knowing of this order, which is prior in time, while making the petition and coming before your lordship, is not making out that case. The petitioner is not preferring an appeal from the order of 17th of October. But the petitioner is making these submissions from the bar without having that case in hand, because it is convenient for him, because if that case is not there in the writ petition, the respondents need not come and reply to it, will not be prepared with regard to it. So, Malad, it is Malad hitting under the belt.
Hitting under the belt?
I could surprise him at least with something.
Possibly not. Pradeep, ওই বইটা এলো?
But I have
বইটা
the.
you have
Let
to
me take it from my. এই প্রদীপটা দাও।
কপিটা দেখালে হবে না। I need the hard copy. No, soft copy can be brought up. I need the printout of the instruction that you read out just now.
Malad,
Inspection.
kindly gives me some time.
And one thing only I heard Mr. Bandyopadhyay reading that on 19th September they found that the interiors are going on in the flats. So then nobody was occupying on 19th of September. That's not the inspection report. If they had stopped on that day, then these persons would not have come and started crying before the court.
No, these people may have paid prior to that.
No.
Whether
Now
interior
they are occupying. Now
21
they are,
you say.
no,
21,
now,
22.
now they are occupying. At that point of time, they were not physically occupying. Highly appreciate. That's the report of the municipality, that internal work was going on.
So they say they were occupying.
That then the municipal inspection report is incorrect.
Why?
They are saying that internal.
So in an occupied portion, they cannot do it.
Lord, I tell you, Lord, if the report doesn't say that people are occupying, it says that interior work is going on in the flats.
Interior work
The order
going
of
on.
17th October says they were occupying.
No, I am on the 19th September. It doesn't say that people are occupying on the report. Report is silent on that. And report says interior is going on. That means it is not. It could be presumed that on that day nobody was physically occupying. They may have invested.
Let us see.
Kindly see.
Let us see.
17th October persons are given or not.
Who are you appearing for?
That purchases both of us.
Very well.
That day only all the reports that purchases were present before the court, and Justice Gangapathyay took all information of the purposes.
It hardly matters. If the construction is illegal, it has to go. Let them stay. You want those people to remain alive? So very poor people should die. This is your submission.
court. They are suffering because of their cost. Lordship, in this occasion, where children go, Lordship, kindly consider this.
What do you mean to say where they will go? They should have invested their money in a property which has been sanctioned and not pay to buy a property which is an unsanctioned one. Where they will go? Is this? So ignorance cannot be. Ignorance, you cannot rely upon ignorance. You cannot. Then why are you making this type of submission? No, Lordship. You save your life first. What will happen if this building comes down? Only because they are poor, does it mean that they are meant to die? It is not so. Try to understand what type of submission you are making.
In this situation, Lordship, what is the
Life is far more important. Then
প্রদীপ কি একটা প্রিন্ট করলে? একটা প্রিন্ট করলে?
দেখি একটু। এটা
Not, I'm getting it printed for the book.
এত আবঝা আসছে কেন?
এই তোমাদের ইমেল আইডি বলো তো, তোমাদেরকে পাঠিয়ে দিই। ইমেল আইডি বলো। হ্যাঁ? What? শুনতে পাচ্ছি।
এতগুলো করে মোটামুটি ওই হাম্বল
See, the inspection report, Mr. Bandyopadhyay, really does not say whether this flats are occupied or not.
Well, the order of 17th October says so, Malad. There was an interrogation in the court.
Order is all right, but then your officers were there. I see the signature of two engineers.
Yes.
Assistant engineer, two separate assistant engineers. See, they have signed. Report endorsed, left side. Who endorsed? I could not realize.
Construction or sanction plan, availability of sanction plan or construction being in terms of the rules or not, well, that is not dependent on occupation. Probably that is why it is not being-
Absolutely.
No.
No. That is all right.
Not
It is also paras incorrect because occupation
all
cannot
right.
be an illegal construction. There has to be
They are
occupation
already, it is already an illegal construction and people are occupying it. Don't make this type of submission.
I'll address.
See, the division bench has recorded that they are unaware, they are ignorant of the provisions of law. So without a completion certificate, one is not permitted to enter into a flat.
Division bench says the municipal officers are unaware.
The others are also unaware. That is also recorded. The without a completion certificate, you cannot enter into a flat.
Yes.
You go and see in how many matters you'll get the completion certificate to be issued where they are occupied. Most of them, they occupy it in an under construction property. There is no sewerage connection, there is no water connection, no electricity connection. They are over there. And these officers are not taking steps. What can be done?
That is what I'm trying to address, your lordship.
This is the portion they have purchased. Only to
I told you in the other matter, if a flat, regular flat costs ₹10, you will pay ₹2 and then you will cry. I have paid ₹2. Why will I not be permitted to stay? Why will I be thrown out of there? Then pay the money and obtain flats in constructions which are legal, which are authorized. You cannot go and pay money and buy anything and then say that somebody come and save me. You all have got lots of money, go spread it. But that does not mean that the unauthorized construction would be permitted to remain. Please come. Perused the minutes of the meeting dated 29th of November, 2023. Stop.
No, শুধু 13 to 15 না, পুরোটা নাও, শুধু 13 to 15.
The said meeting was conducted in compliance of the direction passed by the court on 17th October 2023. 17 October. The minutes record that the Bidhannagar Municipal Corporation is guided by the Municipal Corporation Act, 2006 and the West Bengal Building Rules, 2007. Stop. Neither the Act nor the rules framed thereunder, nor the law governing the field provide for regularization of a building constructed beyond the sanctioned plan, or authorizing an unauthorized construction. Such provision cannot be inserted by the parties of the meeting and has to be left to the competent authority, being the legislature. Stop. The committee, acting in accordance with the direction passed by the court, tried to find out a solution to save the occupiers of the building, who were found to be poor and living almost in subhuman life. The committee was of the opinion that the occupiers have been duped either by the co-sharers/owners.
But this was found by the single bench, my lord, not by us. It is already recorded in the order.
No, there is something else to it. By the developers, inciting them to buy property for a better living. Caught unaware of the myriad of laws, the occupiers purchased flats sans the knowledge of law or the requirements thereunder. These words possibly was not there. Duped is all right. Duped is all right. Due diligence may not be in their dictionary when day-to-day survival is a challenge to most. Stop. These persons have wrung their lives saving to buy a property, to have and give a decent way of living to themselves and their family. Paragraph. Under such situation, the committee was of the opinion that demolition is not being discussed on humanitarian ground, as the same will leave these hapless people under the open sky. Stop. The sympathetic approach has been adopted to save the inhabitants of the construction, which was made in an absolute illegal manner without obtaining any sanction from the corporation. Stop. Paragraph. Though it appears that the corporation has adopted a sympathetic approach, but the fact remains that if the construction in question collapses and an accident takes place, as has been noticed in the recent past, comma, then valuable life and property will be at stake. Stop. Keeping in view the safety and security of the occupiers of the constructions which are made, devoid a sanction plan, comma, the court is not inclined to accept the recommendation of the committee. Stop. Next. The court in the paragraph, the court in the order dated 17th October 2023 recorded that on humanitarian grounds, the order of demolition was not passed on that day. Stop. The said order may be passed after the festive season. The court further recorded that sympathy cannot be a factor while passing an order in terms of law. আপনি ছেড়ে দিন, সুললিত বাবু লিখে নেবেন। Sympathy cannot be a factor while passing an order in terms of law. In fact, the court in the order dated 16th October 2023 clearly recorded that no building without any sanctioned building plan shall be allowed to remain, and the illegal construction is to be demolished. Stop. Next. As it has been admitted by the developer in question that that the construction of the G+4 storied building has come up without any sanction at all. Accordingly, there is no other option but to direct the corporation to demolish the unauthorized construction. Stop. Next. Did you get that act?
Yes,
Promoters and Developers Act.
Lord, my lord may have a look at section 3 first.
Yes, section 3 is there.
Lord, kindly have a look at section 3. Just give me a second, Lord. Section
Whether registration has been
section
made or
3,
not.
Section 3, subsection 1, kindly have a look at.
Yes.
Every promoter who constructs or intend to construct in any area in which this act comes into force, a building for the purpose of transfer of such building by sale, gift or otherwise shall at least 90 days before the commencement of the construction such building in such area make an application to such officer or the state government hereinafter, and the state government may appoint for registration of his name in the application shall be in such form shall be prescribed. Then kindly, my lord, come down to subsection 2F. Subsection 2F.
Yes.
Subsection 2F says, subsection 2 says every such application shall be accompanied by a statement containing the following particulars and documents. What are the documents? 2F, sanction plan for construction of building under any law for the time being in force or when the plan is not sanctioned at the time of making application. Subsection 1, an undertaking by the applicant to that effect, the plan will be submitted by him soon, provided the name of the applicant shall not be registered and the application shall not be granted permission to construct of the building under subsection 5 until the sanction plan is submitted. Then, apropos to this, kindly take note section 13. My lord, kindly got section 13.
Yes, penalties.
Any promoter who fails to comply with the or contravenes any provisions of this act or the rules made thereunder shall on conviction be punished with an imprisonment for a term not less than 3 months, which may extend to 3 years, or with fine which may extend to 5,000 rupees, or with both. And a promoter who commits criminal breach of trust in respect of any sum of money as advance payment or deposit referred to in section 7 shall on conviction be punished with imprisonment for a term which not less than 6 months, which can be extended to 4 years, and 50,000 fine. Then 14, where an offense under this act has been committed by a company, that's for the company. And section 7, Lord, says that notwithstanding anything contained elsewhere in this act, any other law for the time being in force, a promoter shall before takes any advance payment or deposit which shall not be more than 40% of the sale price of a flat, enter into a written agreement for sale of each person intends to purchase such flat, and the agreement shall be registered under the Registration Act, and such agreement shall contain such particulars and shall be accompanied by such documents and copies thereof. So he ought to have entered into an agreement, registered agreement, and that ought to have not accompanied with the sanction plan.
According to the provisions of the West Bengal Municipal Corporation Act, 2006, no person shall use any piece of land as a site for erection of a new building, except in accordance with the provisions of the Act and the rules and the regulations made thereunder. In relation to such use of land and erection of building. Stop. Every person who intends to erect a building shall submit an application to the commissioner for sanction in such form, comma, containing such information or documents, comma, accompanied by such plans and specifications in such manner, comma, as may be prescribed. Stop. The Act further lays down that no person shall erect or commence to erect any building or execute any building work specified except with the previous sanction of the commissioner and in accordance with the provisions of the chapter and the rules and the regulations made under this act in relation to such erection of building or execution of work. Stop. Paragraph. The building in question has been constructed at the behest of the respondent numbers 8 and 9, who are the promoters and developers. Stop. According to the West Bengal Building, bracket open, regulation of promotion of construction and transfer by promoters, bracket close, Act, 1993, every promoter who constructs or intends to construct in any area in which the Act comes into force a building for the purpose of transfer of such building by sale, gift or otherwise, shall at least 90 days before the commencement of the construction of such building in such area, make an application to such officer of the state government as the state government may appoint for registration of his name and for permission for construction of such building. Stop. Every application for construction is to be accompanied by a statement of several particulars and documentary evidences. Especially the sanctioned plan for construction of the building, or where the plan is not sanctioned at the time of making application, an undertaking by the applicant to the effect that the plan will be submitted by him as soon as it is sanctioned. Stop. The name of the applicant shall not be registered, and the applicant shall not be granted permission to construct the building until the sanction.
Okay. Petitioner entered in representation.
Paragraph. In the instant case, the respondent numbers 8 and 9 commenced the construction and also concluded the same without having any sanction plan and in contrary to the provisions of the Act, 1993, as well as the Act, 2006. Stop. Next. According to the Act of 1993, any promoter who fails to comply with, or contravenes, any of the provisions of the Act or the rules made thereunder, shall, on conviction, be punished with imprisonment for a term not being less than 3 months. এটা লিখতে হবে না, এটা কেটে দিন। এই প্যারাগ্রাফটা বাদ দিন, এনি প্রমোটারটা বাদ দিন। There is a provision for arrest. Under which law? And it's a cognizable and non-bailable offense.
Municipal Corporation Act এরকম কোনো provision আছে? না।
Please find out possibly the Apartment Ownership Act, please check.
The Apartment Ownership Act, that is for the apartment owners. The 1972 Act, that doesn't apply for the developer.
Lordship, that provision is in under the Kolkata Municipal Corporation Act.
That is for 401.
It is 401 that the anticipatory bill that the promoters used to take from the district judge.
Here also there is
Sir,
one
there is no
provision I
such-
checked up somewhere.
नहीं देखिए हम ऑलरेडी कट कर दिए केएमसी में केएमसी में
দেখ তোরা পাস করে
आराम से देख रहा है
সব ভুলে যাচ্ছে রে
अभी लोग जा सकते हैं सब
Lord, my lord, may I have a look at section 395 of this act, Lord, for a second. That is for cognizance of offences,
395 of which act?
2006 Act.
395, 2006 Act.
All offences under this act and the rules or the regulations made thereunder, whether committed within or outside the corporation area, shall be cognizable by the judicial magistrate having jurisdiction, and the magistrate shall not be deemed to be incapable of taking cognizance of any of such offence or any offence made under any law repealed or by reasons only for being liable to pay property tax and benefit of the municipal fund. No.
so liable for the
By reason only of being liable to pay tax. That is the only reason for.
Non-payment of taxes.
No. It doesn't say that, Lord, it says that all
Cognizable any
offences under this act,
All offenses.
yes,
on the rules
all
made-
offences shall be cognizable by the magistrate and shall not be deemed to be incapable of taking cognizance of any such offence or any offence under any law repealed by this act by the reason only of his being liable to pay tax under that or any property. So that cannot be an, Lord, exception. So see, where is the penalties and offences under this act? There has to be offences. Penalties পাওয়া যাচ্ছে 196 এ miscellaneous 384
196 power of less service. Right. Power of system.
384 385. Whoever contravenes any provisions of this section or subsection of any section, subsection or clause, or any proviso or any section or subsection or clause of this act mentioned in column 1 of schedule 5 shall be punishable with fine, which may extend to the amount, or with imprisonment for a term which may extend for the period specified in column 3 of the schedule, or both, in case of continuing contravention or failure, with the additional fine, and may extend to the amount of column 4. Kindly take the column.
Yeah. Schedule 3, no?
This is only after conviction, isn't it?
Yes.
This is the penalty, so it has to be
That is not what is there. I'm showing you.
Schedule 1. Column 1 of Schedule 5.
Yes, Lord, kindly take Schedule 5, section 266.
Unauthorized direction.
Yes, 6 months imprisonment. Fine or imprisonment. And occupation, there also a fine of 500.
Occupation without a completion certificate.
So this is an offense under this act also.
Obviously, it's an offense. We make construction without any sanction. It's an offense. Whether it is under the 93 Act or the 2006 Act, it is an offense. Acha, ki bolam?
Everything is in knowledge. वो आप आपका बिना कुछ अभी से तोड़ने का ऑर्डर दे दिया प्रमोटर को ढुका रही और क्यों उठा होगा
Complaint was lodged. Complaint of unauthorized construction was lodged before the commissioner of the corporation and the executive engineer of the corporation with copy to the officer in charge, South Bidhannagar Police Station in April 2023. Stop. The present writ petition has been filed on 11th of May 2023. Stop. Next. In response to the complaint lodged by the petitioner, an inspection was conducted by the engineers of the Bidhannagar Municipal Corporation on 18th of September 2023.
15th September. Inspection done on 15th September.
Acha, 15th September 2023. And it was found that a G+4 storied building was standing at the plot number RA181, Shantinagar, sector IV, Salt Lake. In the ground floor, 3 shop rooms were found on the roadside, and the rest portion consisted of 3 flats. Stop.
We have not received any notice, my lord.
Second floor consisted of 4 flats, and rest portion of the floor consisted of 5 flats. Interior work was going on in most of the flats. The sanction plan could not be produced at the time of inspection. So ground floor, there are 3 shop rooms and 3 flats. In the second floor, 4 flats and 5.
5 in the rest of the floor.
4 and 5, that means 9.
9 and 3.
9 and 3. 12.
No, in the second floor, 9 flats.
Second floor.
4 flats, 4 number of flats, and rest 5 number of.
Rest floors. Kindly see the bracket. Rest portion of floor. Rest of other floors have 5 flats.
Second floor consists of 4 flats.
And rest portion bracket floor.
That means floor means the second floor.
Third and fourth. Third and fourth.
All the 3 floors.
Floors have 5 flats
each.
What about the first floor?
What about the first floor?
Not stated.
Nothing is mentioned. Ground I can understand. Second I can understand.
What about the first floor?
Nothing is mentioned about the first floor.
My lord, we have not received any notice, my
What
lord, for
type
such
of
inspection, my lord.
report it is being prepared? Anyway, legal.
27. My lord, we have not received notice of that inspection, my lord. Any such notice, my lord. We
What
have
will you
not
do with
received
this notice?
notice of inspection,
What
my
will
lord.
you do with this notice?
My lord, lordship, kindly
What
consider.
will you do? You tell me what will you do
Lordship.
with this notice?
Lordship, the
Will this notice help you to get the sanction plan?
lordship, respectfully, I am submitting your lordship the entire difficulties that your lordship. Kindly have a look, page 25 of the writ petition, your lordship. The petitioner, your
Show
lordship.
me your sanction plan. The court is not concerned with anything else.
Lordship.
I
Lordship.
only want to see whether you have a sanction or not. Nothing in more than that.
Lordship, why I am your lordship, the placing page 25. Page
No, don't
25
place.
is the agreement between the petitioner and the private respondent, your lordship. After completion of the building, the petitioner lost this complaint, your lordship.
So what? It cannot be done.
After completion. And he is equally responsible for all the acts, your lordship. The petitioner, your lordship. He already mentioned in the writ petition that he is one of the co-owner, your lordship. And kindly have a look, the agreement, your lordship, the content of the agreement, your lordship.
Right. A hearing was scheduled to be held on 29th of September 2023 in the chamber of the Commissioner of the Corporation, and please give me the addresses. I cannot read.
One is first is Pachipala Police.
That is the petitioner.
Second one is Osman Ghani. And third one is Imtiaz Ahmed.
Who is Osman Ghani? Imtiaz Ahmed, I can see the respondent number 9. Must be, son of Osman Ghani. Javed Hussain, yes. Right.
We have not
Achha,
received, your lordship, 8 and 9.
And notice of hearing was issued to the writ petitioner and the private respondent numbers 8 and 9. That is the developers of the subject property. Step next.
And the envelopes we have given in the third last and fourth last.
The envelope and the track report showing delivery of the notice of hearing to the addressees are annexed with the documents placed before this court by the learned advocate representing the Bidhannagar Municipal Corporation. Addressee left without instruction. Pachipala Pule. Insufficient address. From the track report, it is not very clear as to whether the addressees actually received the notice of hearing or not. Stop. Paragraph. Be that as it may, fact remains that the construction in question is an absolute illegal and unauthorized one, and the same is liable to be demolished. Stop. Next. The respondent number 11, that is the station manager within brackets South, WBSEDCL, is directed to immediately disconnect the electricity connection at the subject premises. Stop.
Malad, we have not effect any new connection. Only the earlier connection will continue.
Yes, whatever is there, disconnect.
Man.
The Bidhannagar Municipal Corporation shall immediately disconnect the water supply to the flats at the subject premises. Stop. Next. The
My
With-
instruction is that there is no corporation water connection.
where from do they get water? From the roadside deep tubes inside the premises? Might be, or maybe from the
Corporation water connection is not.
has not been given. Very well. Acha.
If any, matlab time makes it if any.
If any, water connection, if any. Acha. The Bidhannagar Municipal Corporation is directed not to permit the respondent numbers 8 and 9 to continue with any construction work within the jurisdiction of the Bidhannagar Municipal Corporation. Stop. Next. The
Lord, my lord will kindly, Lord, may I
yes,
kindly record that without permission, Lord, otherwise
without
that without permission, without any sanction, they will not allow them to make construction without sanction. Otherwise, Lord, this might be, Lord, constitute, Lord, as an order, Lord, prohibiting them, Lord, from exercising their constitutional right.
Restriction of trade.
Lord, your lords, Lord, kindly not take me. Otherwise, Lord, only that portion, my Lord, may Lord insert that without permission, they will not be.
I'll think over it.
My Lord.
আচ্ছা আর একটা জিনিস লিখুন how much is the amount that has been collected? Did you add the figures?
ফিগারটা তো অ্যাড করবি
That amount,
17th of October.
these are the Milord statement of the Milord the purchasers, Milord.
How much have you collected?
Milord, whatever I have collected, your lordship.
How
I
much have you collected?
ক্যালকুলেট কর
Whatever I have collected, your lordship, I have already invested in the construction of the building, your lordship. And the remaining is lying with the occupiers, your lordship.
আর এদিকে হচ্ছে আরো It comes to about a crore, near to a crore.
More than a crore.
More than a crore.
Not
all. That is 50%. That is 50% of the amount. ব্যাংক অ্যাকাউন্টটা ফ্রিজ করিয়ে দিতে হবে সমস্ত প্রপার্টি গুলো ডকুমেন্ট
the respondent numbers 8 and 9 are directed to deposit a sum of rupees 1 crore with the learned registrar general of this court within 12th April 2024 as security deposit. Stop. Next. The corporation is directed to initiate proceedings against the respondent numbers 8 and 9 for acting contrary to the provisions of the Act of 2006. Paragraph. The occupiers of the construction in question are directed to vacate the subject property within a period of 30 days so that the corporation can proceed with the work of demolition of the same. Stop. The respondent numbers 8 and 9 are directed to file an affidavit, are directed to file separate affidavits before this court disclosing the bank accounts, and their
properties.
Income tax details.
And the properties, if any, they own.
ঠিক আছে the list of properties owned by the respondent numbers 8 and 9 shall also be indicated in the affidavit to be filed by the respondent numbers 8 and 9.
But kindly restrain them from dealing with their properties.
Stop. Next. The Bidhannagar Municipal Corporation is directed to affix notices at conspicuous places of the subject property, mentioning that the structure is an illegal one and will be demolished. Stop. Next. The matter is directed to appear in the list on 16th April 2024 to ascertain payment by the private respondents.
And lot of filing affidavit.
The affidavits shall be
May I pray one more week, my lord, returnable date.
filed by the respondent numbers 8 and 9 on the adjourned date. Yes.
My lord, returnable date, my lord, kindly fix, my lord, next week of that 16th, my lord.
Why?
Because there is some personal difficulty, my lord.
Whose personal difficulty?
My lord.
Your personal difficulty? There are so many advocates with you.
Only one more, my lord. My junior.
One more? Let him come.
Lord, only one thing, but he will not be, they will not be dealing with their properties. Lord, because if they sell it in the meantime, all the properties dispose of
That
them.
is the reason the corporation will affix that notice.
No, not this.
mentioning
The personal property. The personal properties.
personal property.
Yes.
My lord, in that event, I am praying, my lord, since the petitioner, my lord, kindly see the, my lord, why I am praying, my lord, because kindly consider the candidature of the petitioner also, my lord. My lord, he, my lord, entered into the agreement in the year 2019, my lord.
সেইখানে লিখে দিন
And
the
complaint,
private
my lord, in the year
respondents
2022, my lord.
are restrained from selling/transferring or alienating their personal properties without the leave of the court.
PH, sir. And my lord, the petitioners also receive money from these respondent number 8 and 9, my lord, because they are the co-owners, your lordship.
Sue them. What more can the court say?
Lordship, we are the victim, your lordship. Now, lordship,
them.
because your lordship, the thing, my lord, everything is happened, my lord, in front of the petitioner, your lordship.
Yes.
He is one of the interested person, your lordship. He is equally responsible for all the acts, your lordship.
How much money have you paid to the petitioner?
Lordship, whatever required, I have paid, your lordship.
How much?
But
Give me
now,
the figure. Give me the figure.
lordship, I will submit on the returnable date, your lordship.
Yes.
I will place, your lordship.
Please do.
Lordship, in the year 2020-22, your lordship, all the persons were shifted in that building, your lordship. Thereafter, lordship, the petitioner, your lordship, complained before the BMC, your lordship. After that, your lordship.
You disclose how much money the petitioner has received.
Lordship, I will.
The petitioner will also
Lordship, I will.
refund the amount.
Lordship, the petitioner is equally responsible for
Yes,
all
yes,
the acts
very well.
done,
You
done by
give
the
the
private
details.
restaurant 8 and 9, your lordship.
You give the details.
Lordship.
So that
Lordship.
it can
They have also annexed their agreement, your lordship.
Very
Annexure
well.
P1. Page 31 is very relevant, your lordship.
Electricity company, Mr. Kole, immediately disconnect.
Yes, yes. We have... My lord, instead of 16th, kindly make it on 18th, your lordship. Instead of 16th, kindly make it on 18th. Instead of
Kids, please take care of your clients. Make them understand. Please make them understand that what is the duty of the court and the duty of them also, what they should do. Have you followed? Take care of these people.
We need only protection, some lordship. We need some protection, lordship.
Yes.
My lord. Well, I have taken the instruction from my client. Where is it? My lord, so far his present condition is concerned, my lord, he is not having much of amount. So I have one proposal, my lord, subject to sanction of this honorable court. I am told that he has got one property in Howrah only, my lord. So with specific instruction of my client, my lord, I am making this
8
submission.
Abhay Banerjee Lane.
Yes, my lord, 8 Abhay Banerjee Lane, Howrah 1. It is around 4 katas of land. I am told there is a prime property. So, and the total amount, well, total land would cost around more than 1 crore. He has got 1/4 of share. So, he is ready to deposit his title deed, my lord, with the registrar. So far, this is concerned. So far, the security of or the concern of this court is concerned. At the same point of time, my lord, may I take this opportunity to submit that since the writ application has not been heard on merit, kindly allow me to file one supplementary affidavit so that I can show, my lord, whether the order under challenge was properly passed or not.
The writ petition was not heard on merits and the orders are being passed on air. How are the orders being passed if the writ petition
Finally,
is
has
not
not
heard?
been disposed of, my lord.
Finally not disposed of is a different thing.
Well, on merit,
You
my lord,
say that the writ
yes, my lord, it
petition
was
is not
interim order,
heard on
subject to-
merits.
yes,
How
my
can orders be passed in
that
that
was the
case?
subject, my lord, that is interim order what I'm trying to submit is.
So what?
Kindly hear me out on a final, my lord, on the merit of this case and kindly allow me to file one supplementary affidavit.
My learned friend
For
was
what
not
purpose? What
to,
is
to show, my lord, that the order impugned herein is, my lord, not proper or valid, my lord.
so that must be there in the writ petition itself. Why the supplementary to be
My
filed?
lord, the stability report, the revised sanction
Stability report? What
for
has
the
stability
building, my lord,
report got
the
to
soil
do?
test report, my lord, that should have been taken into consideration.
Why?
Thirdly, my lord, the plan which I submitted with the for the regularization or revision of
Where
the
is the provision of law?
my lord, that is to be,
Where is the provision of law?
my lord, when this order was because my lord, as per the division bench order, my representation was directed to be taken into consideration, my lord. Then the
Taking
representation.
into consideration your representation does not mean allowing your application for
Absolutely, my
regularization.
lord. That is why, my
First
lord,
of all, you have to show that there is a provision for regularization of constructions which have been made without any sanction.
my lord, the construction that has been made, my lord, you all know, my lord, unless the petitioner certainly could not have raised the construction without the permission, tacit permission of the authority. My lord, I must be candid in this. And my lord, it is equally true, my lord,
Give me the names of the engineers who helped you to raise this construction.
my lord, that I have to take instruction, but
Yes.
certainly it is, my lord, it is,
No,
my
you
lord,
give me the names
it is
of
an
the
open
engineers.
secret. It is an open secret, my lord, how this
Open
building
secret will not do. You have
raised. But
to pin the responsibility
yes,
now.
certainly,
My
my lord,
time has
certainly,
come.
yes, that I am not, my lord, arguing on that issue. What I'm trying to submit is kindly allow me to place all the material documents for the purpose of
Yes, you will place all documents. Let the court pass orders first and we'll see.
As so far the security is concerned, my lord, I have a specific instruction that he is ready to deposit the title deed of this particular property, so that in the meanwhile he can try his luck before your lordship or my lord or any other further recourse. I do not know. But so far this the merit of this case is concerned, my lord.
Today, my lord, on 15th of January, your lordship has passed the order. When, my lord, the prayer for regularization, which has been rejected, impugned in the writ petition, has been dealt with. The application, my lord, for rejection was affirmed by your lordship. It was pending only to enable him to give an undertaking. That order he assailed before the division bench. The division bench saw that it is his prayer on basis of which, my lord, your lordship kept the matter for filing undertaking. Ultimately, he withdrew the appeal. So my learned friend is saying no order on merit is being passed.
So right
No,
now
my
you
lord,
do
there is
not
no
have.
such, my lord, no such appeal has been, my lord, withdrawn.
Saying
You have come in later. Please
My lord,
check
yeah,
up the
that I know, my
documents.
lord. I have come in later.
Check up the documents.
But
January,
but
your
the
lordship's
document
order
that
is
I have been appeared, my lord, some more, my lord, material could have been produced
No,
before
no.
your lordship, my lord.
Some more material is a different thing. But then the orders are all there. The division bench's order is there.
That was my initial order by which, my lord, my representation was allowed to, was permitted to be considered by the municipal authority. That was there. But thereafter, as per the 15th January order is concerned, I am not aware of.
Yes,
any
you are not
appeal has been
aware of.
preferred.
Please go through it.
withdraw it.
আসুন তো কি কত দূর অবধি বলেছিলাম?
না বললাম কি করে যাবে। তোমরা না বললে তো কি করে জানবে?
দেখো তোমার অ্যাপিল হয়েছে, অ্যাপিল উইথড্র করে
বলছে না হয়নি, কি বলবো?
আমি ছিলাম বললাম না, সেটা আমি বলছি
আর
উপরে ফেলে
না না লিখুন learned advocate for the petitioner submits that Right now, his client is not in a position to deposit the sum of rupees 1 crore as directed, but his client is ready and willing to deposit the title deed, the original title deed, in respect of the property at 8, Abhaypada Banerjee Lane, Post Office and Police Station, Howrah, pin code 711101. Stop. Next. The petitioner is directed to produce the original title deed in respect of the aforesaid property and submit the same before the learned Registrar General of this court. Stop. Next. The said, now the petitioner is restrained from transferring / selling / alienating or creating any third party right in respect of the aforesaid property at 8 Abhaypada Banerjee Lane. Stop. Next. The added respondents, that is the flat owners of the subject structure, are directed to vacate in the undertaking. How many days they sought?
3 months sought.
To
My lord,
vacate.
here, my lord, will you hear me for 1 minute, my lord?
Yes.
My lord. My lord, will hear me for a minute, my lord. So, but
Did you mention something? 1 year?
initial.
Again, Milord, the change of advocate, his learned advocate has stated.
Yes, keep it with you. Yes.
My submission is that the Honorable Division Bench has specifically directed to rehear the matter by the Commissioner himself upon notice to all the respective persons. So far as my clients are concerned,
Rehear?
When it was directed to be heard out afresh.
Show me the order.
Milord, that was considered by the appeal of the flat owners for the division bench.
I was not there. I was not.
Yes,
it is my duty.
Show me the order.
Not my client was there. My client was not there. But kindly see the order dated 17th of May 2023.
Which page do I get that?
Mal.
17th
May 2023. Order dated 17th May, passed in MAT 860.
Page.
My application CAN 3. CAN 3, my lord, page 85. Internal page 4. CAN 3, page 84, internal page 4.
Yes.
For the last paragraph. Be that as it may, has got it.
Yes.
Be that as it may, let the commissioner take a reasoned decision on the application of the appellant for regularization of the impugned construction after affording opportunity of hearing to the appellant, the writ petitioner, any other concerned party and or their authorized representative. No notice was given to me. My mutation is done. I am there. I am paying tax. Even if for a
Please don't make these type of submissions that you are paying tax in respect of an unauthorized construction and that has to be regularized.
My occupation is known to the corporation. That is my contention.
How does it matter?
I am the party who is coming under that any
How
other
does this
concerned
matter?
party.
Does it matter?
A division bench pleasure was to hear so that it can be decided once and for all. And that was my contention.
What is to be decided?
Regarding the regularization, whatever the contention of the promoter or builder.
Show me the law regarding regularization. Please show me the law.
I could not find it. But that is another aspect.
What another aspect? You want to hold on to a construction which is illegal?
No, my lord. I want my clients, my lord, money to be secured so that he can be otherwise be safe and secured, my lord. That's all.
And what is going to happen if the structure collapses?
My concern also. That is very much my concern.
0.77 says at whose instance the election was done.
Lord, the division bench on the instance of their appeal, Lord, paragraph page 11, Lord, the MAT number, Lord, I have given, Lord, page MAT 208. Kindly once looks at the order of the Honorable Division Bench. No, ওটা বলছি। Lord, the last, Lord, I have handed over, Lord, MAT 208 of 2024. At the instance of the flat owners, a special leave, Lord, of appeal is being preferred.
Not my client. Not my client.
Yes, yes. There, this issue, Lord, kindly takes up page 11 of that judgment.
Yes.
Page 11 kindly takes up, Lord, first paragraph, Mr. Roy Chaudhury's contention.
Yes.
Yes, Mr. Roy Chaudhury's contention that the appellants are entitled to be heard by reasons of the observation of the division bench in order dated May 17, just now placed by my lord, before my lord, which has been quoted above. It is not acceptable to us that the order was passed in the context of regularization application made by the developer Soumitro. The appellants would have had no concern or connection with such application. Hence, the word any other concerned party in our view would not include the appellants herein. Similarly, the division bench has thereafter clarified.
This has been clarified.
Similarly situated persons.
Absolutely. You lie on the same footing. You cannot have anything better than this. The court was unable to grant relief to the appellants. No infirmity in the order under appeal.
That is your lordship's order on 15th of January.
Well, may I add one thing?
Writ petition.
Well, this order of mutation that my learned friend is agitating, that was, my lord, it is for judicial notice, my lord. That was passed after this order of demolition was, my lord, issued.
That is more so why it has not.
Mutation?
Yes, my lord.
How does it matter?
Even if it did not matter, the corporation kindly appreciate this thing. I'm not speaking about my client, about the whole issue. The application, my representative was pending with them, and they in their own wisdom, they rejected my application for regularization. Thereafter, my lord, they allowed the mutation.
Yes.
I'm asking this question to myself. The corporation aware of the situation, this building is, my lord, illegal. So far, the knowledge of the corporation is concerned. Then how, my lord, they can again mutate the property for the purpose of taking the generating the revenue, my lord.
And the law, it says that even after payment is made of taxes.
But I'm talking about not talking about the, my lord, taking the my lord, the taxation amount. I'm talking about the fact of mutation itself that was done, my lord. After
mutation is for the purpose of collection of taxes.
Collection of tax.
Now, even if after payment of taxes, the corporation has right to take steps.
Yes, my lord.
Then what remains?
Then my lord, what prompted them to regularize their application for mutation? I am asking this question to myself.
Not regularization.
What is pinching is that the corporation has not taken any step till date against the
Now the corporation will take steps.
against the officers, well, under whose
I have
my lord,
requested you to come forward with the names of the engineers
Certainly,
who
my lord.
were responsible to permit you to continue with the construction
I'll
work.
take instruction because this issue needs to be addressed, my lord.
Yes.
It's only because developer cannot certainly be made a scapegoat subject to correction, my lord.
Achha. Developer is making money and the developer is being made a scapegoat.
The money, my lord, knows it's not only one person is making money.
Out of 10 constructions you make, hardly one has a sanction and all 9 are illegal.
And my lord, all the 9 does not belong to me, my lord. All the 9 developers, all other developers who are also thriving in the same locality, say under the my lord, the protection of the same corporation, my lord.
You complain against the other, somebody else will
Certainly, my
complain
lord,
against
I
the
have
third
advised
one.
them for appeal, my lord. I do not know how far I will succeed, but that is definitely one issue that it needs to be addressed.
The corporation কোনটা কেটে দেবেন না directed to vacate থাকবে তো ওটা directed to vacate. There was a direction passed on the last occasion within which time they are directed to vacate.
The last order, my lord, your lordship. Last order টা কবে ছিল?
20th March.
20th March.
The court is not inclined to grant more than 3 months time for vacating. So the same may be demolished. So March in কি বললাম directed to vacate. The property within the time limit as specified by the court with a order dated 20th of March 2024. Stop. Next. The জল আর আলো কেটে দিতে বলেছি? জল আর আলো কি কেটে দিতে বলা হয়েছে সকালবেলা? ওটা তো বলা হয়ে গেছে তো। আচ্ছা, ওয়াটার আর ইলেকট্রিসিটি টু বি ডিসকানেক্টেড। আচ্ছা, আর
সিকিউরিটি আমি বলছি তোমার সিকিউরিটি,
হুম,
আমার ক্লায়েন্টের সিকিউরিটি আমি বলবো এবার।
I am told, my lord, there are 2 floors which are, my lord, authorized.
2 floors?
Which is authorized, my lord.
No, the portion that is authorized,
My lord,
no order is
Sound
direction.
and partly first.
Partly first. With those, the court is not passing any order. Only with regard to the unauthorized portions, those will be taken care of. Acha. The list. Oh, the petitioner is directed to file an affidavit disclosing the bank account details, disclosing his bank account details and the details of his income tax. Stop. Next.
My lord can mention is an affidavit of assets also. In the company matters, they use the affidavit of assets.
The matter is made returnable on 10th of April, next Wednesday. You bring your title deed as well as why?
Today is, my lord, already 3rd of April, my lord. Kindly,
10th of April.
kindly allow, give us some more time, my lord.
I will check up the order that has been passed and I will make necessary
My
modifications.
lord, make it an affidavit of assets because that.
Yes, affidavit of assets.
I must say, my lord, he is not a bad promoter only, he is a bad son also. But I have inquired the property which he is now, my lord, going to, my lord, file the original deed. Here, my lord, it is his father's property. Father died. His mother is not living with him. The mother is living in that property. It is his mother's, is also a co-sharer. But he is living
Of
in
which property? 8?
of the property 8,
And
which he wants to, my lord, deposit the title deed.
My mother has.
Mukherjee's client was a partner to him. And Mr. Mukherjee's client
Yes,
is for that reason very well know about
Yes, that's why I said.
activities.
That's why I say his mother is living in that property alone.
So, my lord, except light and air, we are not getting anything.
Light?
Except natural light and natural air, we are not
Sunlight.
5 lakh টাকা দিয়ে property কি?
Good.
My lord, at least 2 weeks time may be given, my lord.
আমি দেখে নেব, চেক করে অর্ডার দেব।
My lord, may I seek one indulgence? Instead of 10th of April, kindly give me 2 weeks time.
12th of April, 2 days time.
Only after the.
No, মানে 12th of April আগে।
You won't be there?
My lord, kindly.
Only on 10th, relative.
2 weeks, my lord, another one.
11th of April.
11th is a holiday.
Oh, 11th is a holiday.
13.
Then 12th, what is the difficulty? You are not there. 15th of April. 15.
No, I am for the respondent.
My lord directed me to serve the presiding officer, my lord. I have served. My lord, this is a panchayat election matter.
No, I am for the on behalf of the presiding officer. I have filed the report in a form of an affidavit, my lord. My fault
এই
because
যেটা জেরক্স করে দেওয়া হলো না এই আইনটা, এখানে একটা অ্যামেন্ডমেন্ট আছে, সেটা আমি পাচ্ছিলাম না এটাতে। আমি তাই ভাবছি কোথায় গেল, আমি গিয়ে চেম্বারে দেখলাম, হ্যাঁ ঠিক আছে। Yes.
My lord, this is my fault, my lord, not intentional. I am a psychiatric patient and under treatment since 2012.
I cannot follow. What is?
My lord, I am the
Use the microphone. You are the petitioner.
my lord, he is appearing for the presiding officer. Kindly see the last order of your lordship, my lord.
Oh, he's appearing for the presiding officer. What is your grievance?
My grievance is he has not signed the ballot paper, my lord. My lord, kindly see your lordship last order, my lord.
How many?
My lord,
400 ballot
yes,
papers?
I lost only 17 votes, my lord.
7 votes.
7.
What is your stand?
My lord, I have stated paragraph 1, 2, 3, 4. My lord, presenting my client is psychiatric patient and under treatment since 2018, my lord. My lord, he has forgotten at the time of issuance of the ballot paper, not putting his signature, even not given the seal, my lord.
Now see, commission engages somebody with psychiatric problem. Yes.
There's a document.
400 ballot papers not signed and the person lost by 7 votes. What is to be done? The election has to go.
In what matter? My lord, before the Honorable Justice, my lord Mantha. Now, my lord, the issue that was raised that whether, when I appeared in that matter on behalf of state, and the issue raised that whether a person who wants to appear in any general election, parliamentary election, or in any general election, whether, my lord, that should be considered as for public interest or not. And my lord said that yes, it is for public interest, it has been held. So, this is for public interest. And
Public interest, psychiatric patient is being engaged. Did you intimate the commission that you are suffering from this problem? You have mentioned.
At the time of
Where did you mention? To the
paragraph 1.
No, the fact that you brought this to the knowledge of the commission. Why did you not bring?
Then he should have been relieved from that.
Yes. No, but then relieving from this duty may be relieving him from the job. He has this in mind.
That means, my lord, apart from my lord, the fate of the candidates, my lord, kindly consider one thing.
The job that he is performing.
My lord, the franchise right to vote, 400 persons right to vote, that also, my lord, gone.
Yes.
They exercise their right, but
There
it
no
became
result.
futile because of that.
Yes.
But at the time of training, my lord, I have requested them to
Show me some document.
that no document verbally. I have requested them. Paragraph 1, I have stated.
What is the work that you do?
Teacher, possibly.
Teacher.
Do you teach? Are you in a position to teach? Psychiatric problem, what do you teach to your students? What do you teach? Assistant teacher. When did you get the job? How much money did you pay to get the job? 2018.
I'm physically unfit.
Yes, that is the reason why he has not disclosed. Because of my mental disability, I have forgotten to sign and stamp the ballot papers. Can this be taken to be a ground?
It's a very serious matter.
Extremely serious.
And 460 ballot papers. A matter of jokes.
9 votes. Margin 9.
No. We not defeat is something
No.
else. The thing is that the right to vote, that has been diluted, that is taken away. Really.
The ballot papers must have been preserved.
Yes.
So in that case, if recounting is done, treating them to be valid, then that will save at least the election.
Yes. That's
Isn't it?
my lord, the sanctity of the election, my lord, I think does not depend only on this, my lord, trivial issue, so that he has forgotten. The thing is that the original ballot paper was there, whether they out of those 160 ballot papers, 1060 ballot papers, those are the part of those ballot papers or not. These are to be looked into. And my lord, the franchise right that has been exercised.
One more thing, Your Lordship. On the last occasion, when another matter I don't remember, I had submitted 3 judgments before Your Lordship. I had pointed out functus officio.
Yes.
With the declaration of results, the
Yes.
function of the election.
Patna,
Yes,
Patna
yes.
High Court judgment.
Jharkhand and
Jharkhand.
Lordship's own judgment.
Yes, Govindo De.
Yes.
Yes.
So in that recounting whether we will be able to do or not, Lordship can remand this. If this is a fit case for recall, then the Election Commission will decide on this, keeping this affidavit under consideration. But still, if Your Lordship gives me 1 day's accommodation, I will discuss this case and come back.
It's better you do that. Instead of
I think, yes,
taking
I
a
think,
decision, let the commission
let the commission take a decision. Let the
Please
commission
come.
take a decision.
Report in the form of affidavit has been filed by the presiding officer of the polling center, and the reason mentioned by him for not affixing his signature in the reverse of the ballot papers, reverse of 400 ballot papers, is that he is a psychiatric patient and is under treatment since 2018. Stop. The presiding officer has annexed several medical certificates in support of his statement that he is suffering from mental disorder. Stop. Next. In the affidavit, the presiding officer has averred that due to mental disability, he forgot to sign and stamp the ballot papers. Stop. Next. Paragraph B, it recorded that the petitioner lost the election by only 7 votes.
9 votes, my lord. 9. I have written 9. 9.
9?
Yes.
Acha, 9 votes. Stop. Next. The paragraph on account of the non-affixation of the distinguishing seal and the signature of the presiding officer, comma, the ballot papers were treated as cancelled. Stop. Because of the mental disability of the presiding officer, the votes casted by the voters have become null and void. Stop. The learned advocate representing the presiding officer submits that his client drew the attention of the commission with regard to his mental disability, but there is nothing on record to prove that the aforesaid health condition was made known to the commission. Stop. Next. In such a situation, the commission is required to take a call as to whether the votes can be recounted by treating the 400 ballot papers.
398 as per my video report.
Acha, 398 ballot papers to be precise as valid ones. Stop. In the event the same cannot be taken to be valid votes, comma, then the court has to decide as to whether a repoll is required to be conducted in the said constituency. Stop. Next. The matter is made returnable on 26th of April, 2024. Very many matters are there on that day. You speak to your officers. What is to be done?
ওটা দেখে নিন
এইটা আমি দেখে নেব, এটা তো ইলেকশন কমিশন স্ট্যান্ডার্ড।
ইয়েস
কবে হবে 26 এপ্রিল?
হ্যাঁ দাদা
Get.
Non-compliance of the previous order was brought
I am
to
for the
Lordship's
Birbhum
notice
Jila
that-
Parishad matter.
Yes.
Tomorrow is a date fixed for hearing by the
Of?
authority. Tomorrow, this
Tomorrow is the
4th
date fixed for hearing of what?
by the authority, in terms of the direction of this Honorable High Court. There was a previous first round of litigation. There was direction. That direction was not complied with. Now they have given a notice to hear on tomorrow.
Show me.
And in the file they have report. They have filed this.
Where is the report?
আগে ফাইল করা হয়েছিল।
20th of March 2024, the report was affirmed.
Yes. Annexure.
আপনি পিটিশনার?
4th of April 24. I'll please come. From the report filed by the Deputy Secretary, Panchayats and Rural Development Department, it appears that 4th April 2024 has been fixed for hearing of the issue before the Secretary of the department. Stop. Next. The parties are directed to take steps on the date of the hearing. Stop. Paragraph. Let the fate of the hearing be placed before this court on the adjourned date. Stop. List on 17th of April.
With an advance copy to me so that I can address.
Whatever is the order, you have to challenge it, isn't it? Just want to see that the order is passed, it is fixed.
My application. Affidavit of service notice for upgradation, Lordship. A piece of land was purchased by the petitioner, Lordship. The land is classified.
Who is your other side?
Mr. Lolit Mohan Mahato along with Mr. Prashanto Bihari Mahato.
Where are they?
They usually appears before this
Please
court.
send somebody to room number 5. Room number 5, please send somebody. Yes.
Lordship, the land was purchased by the petitioner in the year 2008, Lordship. That land has been classified as Hart, Lordship. It is a 100 years old Hart, Lordship, a trading venue for the local people that caters the needs of the basic needs of the local people, as also that it is.
What is sold in this hut?
All the vegetables, Lordship.
Vegetables.
Vegetables, Lordship. Some stalls are there.
Cattle is not sold.
No, not cattle hut. Only vegetables are
Vegetable
daily
hut.
market. This daily
Yes.
market in the Lordship. What happened, Lordship? When the respondent number 10, who happens to be the local MLA, Lordship, he is standing in the way in smooth functioning of the state hut. He moved a petition before this honorable court. Lordship, kindly see the order at page 27, last but one paragraph, Lordship. At page 27, in case the respondent authority shall ensure that the private respondent, who is the respondent number 10, Lordship, MLA, local level, shall not obstruct the running of the daily market by the petitioner till by a competent authority. That the police keeps one so vigil, etc. That matter was disposed of. Thereafter, Lordship, the license which was issued, Lordship, by the executive officer at page 25, Lordship.
Yes.
At page 25, Lordship, license was issued by the executive officer, Rotua 1, Panchayat Samiti, Malda, for conducting daily market, Lordship. At page 25, for the period from 1/4/2023 up to 31st of March 2024. There is a provision in the Panchayat Act under section 117 for renewal of the state license, Lordship. He applied, Lordship, at page this year, Lordship, at page 29, on 2nd February 2024, before the BDO of Rotua 1 Panchayat Samiti, and then on 7/2/2024, Lordship.
This has not been considered.
No, Lordship, no steps.
Please
Since
come.
that person is standing in the way still, that MLA.
Please come. The Panchayat Samiti issued a certificate of registration for trade of special nature for running daily market in favor of the petitioner, and the same was valid from 1st April 23 to 31st of March 2024. Stop. During the pendency of the said certificate, the petitioner applied for renewal of the same on 2nd February 2024. Stop. The same is yet to be considered and disposed of. Paragraph. Specific case of the petitioner is that the local MLA, being the respondent number 10 herein, is standing in the way of renewal of the said certificate. Stop. Next paragraph. Where is your service?
Service has been effected upon respondent number 10 and all other respondents, Lordship, at page 12 of the affidavit of service.
Very well. None represents the respondents. Stop. Affidavit of service filed in court is taken on record. Stop. As there is a provision for renewal of the certificate,
as per section 117 of the Panchayat Act,
the authority ought to have taken a decision upon the application for renewal made by the petitioner. Stop. Next. The respondent authority, who is the authority?
Executive officer, the respondent number 6, Lordship.
The executive officer ought to have taken a decision within the validity period of the license so that the petitioner would not have to stall the daily market on account of expiry of the license on 31st of March 2024. Stop. Next. As it appears that the license is the prayer of the petitioner seeking renewal of the certificate of registration is pending consideration. Accordingly, the instant writ petition is disposed of by directing the respondent number 6, being the executive officer and the block development officer, Rotua 1 Panchayat Samiti, to take steps to consider and dispose of the prayer for renewal submitted by the petitioner on 2nd February 2024 in accordance with law at the earliest, but positively within a fortnight from the date of communication of this order. Stop. Paragraph. Learned advocate for the petitioner is directed to forward a copy of the application for renewal dated 2nd February 2024 along with the earlier certificate of registration to the aforesaid respondent at the time of communicating the order of the court. The writ petition stands disposed of.
Feels a decision by the BDO, Lordship. No interference in running of the daily market, Lordship.
How can you run without the license?
Without my license also, that can it is the decision of this honorable court, Lordship. In section 117, it is written, Lordship, Panchayat Samiti can grant license for holding hut or market, but there is no obligation for any person to obtain any license for holding hut or market, Lordship. Judgment is there to this regard.
Acha, likhun to. As the as the petitioner applied for renewal of the license during the validity period of the certificate of registration, and it is on account of the delay on the part of the respondent authority to take a decision in proper time. Accordingly, the respondents are restrained from interfering or causing any disturbance in the smooth functioning of the daily market till a decision is taken by the aforesaid respondent.
I'm grateful. Let the affidavit of service be kept with the
Yes.
Lordship, I am for the petitioner.
Inspector, I am accountable to Kolkata.
Service.
Events all of course, not date to work. Maybe taken up tomorrow.
Why?
Person speaking and yes, please.
Use the microphone, please.
It is the corporation desire to plead this matter before your lordship by Mr. Maluk Kumar Ghosh, so that
It was his desire to plead this matter.
and therefore I am saying corporation desires, my lord.
Very well. 1 minute. Let me hear.
Lordship, I am the petitioner. I was appointed on a contractual basis for the post of sub-registrar in Siriti Burial Ground under Calcutta Municipal Corporation, the respondent authorities. Now, my lord, my grievance is that a notification for recruitment has been posted on 23rd of February 2024 for the sub-registrar, a similar, not the contractual position, a permanent position as sub-registrar under the respondent authorities. And now I have all the qualifications that are required for such application to undertake the examination. Besides having one qualification, that is, I do not fit in the age criteria. The age criteria is 45 years of age, relaxable by 5 years for people working in jobs of similar nature. I have the 5-year relaxation. I am currently 52 years of age with 8 months going on, currently as of this month. Now, my lord, essentially, I am covered by judgments of your honorable bench itself, even by the judgment of the larger bench of this court, which is in Govinda Chandra Mandal versus Principal Ravindra Mahavidyalaya.
Let me see the order passed by this bench.
Yes, my lord. It is in.
Have you annexed it?
Yes, my lord.
That
It is
he
annexed.
appeared twice earlier.
So what?
In the examination, he has given relaxation.
My lord, I
twice.
failed twice,
Twice
but
he
I
has
want to
given
try
it.
one
How
last
many
time.
times he will get relaxation? Relaxation, how many days? He has taken relaxation twice. And we have allowed them. But thereafter, my lord, this is the third time.
My lord, I
They
have
have not
the provision to sit for such examination. My lord, if you look at your order that you have passed, my lord, page number 27 and page number 34, my lord, of the writ petition. My lord, there are two essential criterias. I have to have the initial qualifications from the date of induction, which I have, and I need to be in continuous service even as a contractual employee without any break. And I have been in continuous service since 2010, my lord. And this is the last attempt I'm taking, my lord. I have sat 2 times, I've not been selected. I am close to retirement. I want a last attempt at undertaking this examination.
What is the age of retirement?
My lord, 60.
60?
Yes,
You
my
are
lord.
52, 8 years to go.
My lord, I won't be coming back and asking for another opportunity continuously. It's taxing on me also. My lord, back in 2013, my lord, in page number 19, I had made a representation after being continuously extended, my tenure being extended. I made a representation to the commission stating that please put me on the normal pay scale now.
And
There
then
was
that
no
cannot be
action
done.
taken. No action was taken, my lord.
Action could not have been taken because law doesn't permit.
My lord, at this point, I just want to take the chance of sitting for the examination so that my
And shall I
position
record your submission that this will be the last attempt?
My lord, it will be my last attempt. I have that clarification from client.
This is our objection to that effect. My lord. Then, my lord, others people are there, my lord, employees, they will ask for that.
How
Same.
does
Same
relaxation,
my lord.
how does it matter? You need a qualified candidate. He will contest the selection.
Contestant failed twice, and we have
He may
allowed
fail
him.
for the third time also.
My lord, there is some one judgment, my lord. I am relying on this. Kindly, kindly consider this judgment. My lord, I have no copies. Furthermore, therefore, kind.
Paragraph 6, my lord, in this judgment.
Yes.
6, 11, 12, and 13, and 14. I am relying on this.
Give her the citation also. 2011 AIR SCW 4252. It's better you go through this and come back tomorrow. Mr. Ghosh will be here.
Much obliged, madam.
I'll give.
Make it copy.
Please come. On the prayer of the learned advocate representing the Kolkata Municipal Corporation, let the matter appear in the list tomorrow under the heading সকালবেলার দিকে urgent motion. Urgent motion. Under the heading urgent motion. এই জাজমেন্টটা ফেরত যাবে।
I am hanging it after Xerox. I have no other copy.
Give a copy to your learned friend.
Meeting করুন। ফটো তুলে না করতে হ্যাঁ আমি দিচ্ছি।
Lordship, I am for the petitioner.
Lord, I am
Having the copy of the affidavit of service.
respondent number 5, my lord, private.
I am the respondent municipality.
Lordship, I am the owner of the property by a deed of conveyance, and I have mutated my name, and all of a sudden the respondent number 5 fraudulently executed a sale deed. A title suit is pending before the court below. My prayer is currently not to mutate their name till the disposal of the title suit. The petitioner also made a representation to the municipality, chairman of the municipality, representation page number 62 and 63.
You say you are the owner of the property
Yes, Lordship.
and the private respondent has
Private respondent has fraudulently executed a sale deed.
sale deed
Yes, Lordship.
in respect of the same property.
Yes, same property. So a title suit is pending the lower court below.
Yes.
Title suit number.
Yes. Private respondent who is
Yes,
the
I am.
Yes.
My lord, kindly noted that some dates, my lord. The petitioner purchased the land 1969.
Please come.
My lord, kindly, my lord.
1 minute. The petitioner claims to be the owner of a property in question. Stop. Her allegation is that the respondent number 5 fraudulently executed a sale deed and relying upon the same, mutation has been sought for. Stop. Next. An objection has been filed before the South Damdam municipality, North Damdam municipality, not to proceed with the mutation till the title suit which has been filed by the petitioner before the learned civil court is disposed of. Paragraph. Next.
My lord, I have some submission, my lord.
Yes.
If your lordship kindly. My lord, 1969 she has purchased the property. Thereafter, my lord, 1974 she sold out to my client. She filed a title suit, my lord, 491 of 1997 declaration for title. That's what dismissed for default. No steps was taken. Thereafter, she filed another title suit 278 of 2009. My lord, there is no injunction order. My lord, as the prayer of the two suits are same, I will show before your lordship if your lordship kindly come to the petition, the prayer is same. And secondly, my lord, I have mutated my name before the BLRO, my lord, kindly see that.
Already mutated before the BLLRO, not before the municipality.
No, because my lord, as read petition is pending, for this reason, my application has not been considered by the municipality.
Yes. So, why don't you are a party in the suit? You can obtain orders in the suit court and the whatever order is
My lord,
it
what
will
happened?
follow.
Last suit was filed 2009.
Yes.
My lord, ADSR stage has over in the year 2022. I have filed the written statement in 2024, my lord.
Get it heard and disposed of at an early date. You take steps.
My lord, because my lord, the prayer is same in two suits. One suit is dismissed for default.
This is a good ground before the learned court below.
Right, my lord.
Then
My lord, even if the suit will take, my lord, long time, my lord. In the meantime, my lord, we will not get my name mutated, my lord, before the municipality.
না পড়তে হবে না।
1974, I have purchased.
Learned advocate representing the private respondent submits that she purchased the property in the year
1969.
And she already mutated her name in the records maintained by the Blockland and Land Reforms Officer. Stop.
No, my lord, I purchased 1974.
Acha 74. And has recorded in the BLLR office. ঠিক আছে? তারপর হচ্ছে যে
two suits.
It has been submitted that an earlier suit was filed by the petitioner in the year 1997.
It was
dismissed for default
2002.
in the year 2002. Stop. On with the same reliefs, the petitioner filed a subsequent suit in the year 2009, which is still pending consideration. Stop. Paragraph. It has been submitted that on account of non-disposal of the title suit, the municipality ought not to stay the mutation in favor of the private respondent. Stop. Paragraph. Upon hearing the parties, it appears that the title of the property in question is pending adjudication in a civil proceeding before the competent forum. Stop. Next. Mutation is only for the purpose of identification of the person responsible for payment of taxes. Stop. Ownership of a property does not depend upon mutation, and the same flows from the title deeds. Stop. Next. As it appears that the ownership itself is pending adjudication before the civil court, accordingly, the municipality is directed to take steps in terms of the order passed by the learned civil court in the pending proceeding. Stop. Next. The writ petition stands disposed of.
Grateful, Lordship.
Grateful.
Yes, my lord. I am appearing on behalf of the petitioner, my lord. My lord, petitioner was an employee of the Asansol Municipal Corporation, my lords. Initially, he was appointed under the Pulti Borakor notified area as a clerk. Subsequently, he was promoted as a registrar of the death and come benefits department. In that particular, that is Pulti and Borakor notified area. Subsequently, that Pulti and Borakor notified
What do you
area,
want? Tell me.
Yes, my lord.
What do you want?
My lord, I have been without any proceedings, my lord. One criminal case is pending. I was arrested, but no suspension.
What is
order.
the charge in the criminal proceeding?
Just, my lord.
Is it anything related to your service?
complaint was lodged by the secretary of the Asansol Municipal Corporation.
No, my lord, that is not the complaint. Complaint was lodged by one Jotin Das. That is not the any party of the, not the any employee of the municipality. That is the outsider. The complaint was that his sister names was required to be corrected. At that point, my client has been taken the bribes or asked for the bribes.
That means it relates to your service.
Course of
Yes, my lord.
service.
Yes, my lord. That is pending. But there is no suspension, no disciplinary order, nothing else. In the year 2019, I have
What, you have been terminated or what?
No, nothing.
Superannuated.
Superannuated.
I have already superannuated.
Any
No
proceeding
termination.
initiated? Then how do you withhold the terminal dues? Under which provision of law are you withholding the terminal
The
dues?
pendency of the Millard criminal case, Millard, it was.
No discipline proceeding, no charge sheet, nothing else.
In a criminal proceeding, whatever the order will be passed by the criminal court, it will be taken care of. But what about his terminal dues? Had any disciplinary proceeding been pending, then things would have been otherwise.
No,
But that is not so. Then what can be done?
Millard,
When did you retire?
In the year 2019, my lord, 26/8/2019, probably, my lords.
And the case is pending? Since when?
Since, my lord, that is 2017. He was arrested on 3/4/2017. My lord, he was, my lord, that is the fact that he was arrested at 8:30 or 9 p.m. Complaint was lodged at 12:30 p.m.
That is
a
ground
consideration. I am not on that. I am not.
merits of the trial.
That is that.
Right.
Right, my lords. That is that.
May I, Millard, come back tomorrow or day after tomorrow, Millard? So far as I can recollect, and my learned friend also, Millard, says so, Millard, under the West Bengal Municipal, Millard, service rules, Millard, perhaps he will only get provisional pension.
Do that only?
Millard, I want to sure, Millard.
Very well, please, Ashanta. The
Or Millard,
petitioner
his
is a
representation
retired.
is pending. We shall dispose it of, Millard. If he gets, Millard, under rules, he will get.
It is better you bring something on record, otherwise he will again have to run.
Then, Millard, let me take further instruction and come back.
Mr. Dhol, you also take instructions. Take up the law 1 second.
And I'll
all the rules during the pendency of a departmental or judicial proceeding.
Exactly.
This is a
Judicial proceeding. The petitioner is a retired employee of the Asansol Municipal Corporation. Stop. His terminal benefits have not been disbursed on the ground that a criminal proceeding is pending against him before the learned court. Stop. Next. The petitioner prays for a direction upon the corporation to disburse his terminal dues. Stop. Paragraph. Learned advocate representing the Asansol Municipal Corporation seeks time to take instruction in the matter. List on next Wednesday, 10th.
Matter gets to me, Lord. I have retired from service on 30th October 2019. The PPO has been issued, but till date I have received my gratuity amount.
You have not received?
Yes. Well, they have intimated falsely before the director of pension. That is why some amount has been shown that there is a provisional pension has been released. But till date I have not received any provisional pension or any pension retiring gratuity. And there is a arrear salary also due. Well, that I
am appearing for the municipality.
Yes.
Fact is, but as per ROPA 209, the entire payment is paid. Paid. The pension is getting his, but he is claiming.
Pension getting current pension I am getting, but the arrear pension and the arrear total gratuity I have not received.
He is want to get the gratuity as per the revisional RUPA 2019.
No, only pension, only one pension payment order. That is because I have retired in 2019, pension payment order 2021. That is
Please.
only one pension payment order.
Please show me.
But that is at page 45.
As per RUPA 9, he is getting everything. But he is asking for
Ropa 19,
Well,
but
they
no
are showing
payment is
that
made on the
Page 45, Ropa 19, PPO has been issued.
issue, but without payment on the part of the state government. Who will pay? Number of the retired person asking for the
that's the
payment as per
responsibility
the
of
Ropa
the
19.
That is the
That
responsibility
is
of
the
municipality.
law. Then you have to pay it.
Then question of long hearing is required because the government issue the notice without sending the draft notification to the affected party as per section
They have
23.
released the pension, current pension, according to this.
Please come.
And below that, the pay mentioned that overdrawn
But kindly
pension amount, but that is also not
The
correct.
petitioner is
If the state
retired
government pay, I
employee
am ready to pay.
And I am also entitled to get area salary also.
Navadvip municipality. Stop. The pension payment order
Revised pension payment.
No, that is only a pension order.
of ROPA 2019 has been issued in his favor on 29th of November 2021.
Yes.
Stop. The petitioner alleges that the gratuity, area pension and area salary is due and payable to him. Stop. Paragraph.
Well, total amount into rupees 20 lakhs and 63,514.
Where is that mentioned?
Well, I mentioned at page 55, there is my representation. They have received it, but no reply.
But admittedly, as per Ropa 19, he has got the gratuity, 3,75,000.
Certainly not. I have not let them produce the document.
But then,
which account they have released?
Then, kindly direct me. I shall produce the document. But that is not available.
You say the gratuity has been paid?
Paid, as per Ropa 9.
Well, I have retired in 2019. After Ropa 2019, they have said they have paid the Ropa gratuity after Ropa 2009.
How can you not pay? 1 minute. How can you not pay him according to ROPA 2019? His PPO is accordance with ROPA 2019. And he is bound to be paid accordance with ROPA 2019.
A number of the pensioners is there. But without fund, government only issue the death come retirement benefit rules and the notification. Not the
You are the principal employer?
Yes. So require the approval of the state government, the director of local bodies. Brought the local bodies.
Government issued the pension payment order.
After submission of
No,
Mr.
please,
Maitri,
Mr. Maitri, let him submit. You have seen the PPO. It is issued by the state government.
My submission is so for the pension PPO in respect of ROPA 19, we have municipality has already paid 3,65,000 already paid. Not on 6th February 1990. 6th February 2019 already paid. And Lord, he is asking for ROPA 2019 as per that act, notification, it enhanced to 7,30,000. But the government issued the PPO, revised PPO. But no payment has been made on the part of the government. My difficulty is this, a number of retired employees are there. Fund is not available. If the government pay, within 3 days, municipality will disburse. Within 3 days.
It is for you to bring the money from the government. It is not for the petitioner to sue the government to get the money.
So my submission is, as per section 23, subsection 1 of the General Causes Act, without it is the duty of the authority who has issued the notice or the notification required to accept the complaint and suggestion and accordingly finalize. The government finalized but did not.
Why don't you sue the government? Why is the retired employees have to come to court?
Pay the money.
You will.
A huge number of employees are there.
It is a municipality. Employees will be there. It is not your private house that only one staff will be there. It's a municipality.
So it may be right, but fact is this: one who is direct, he must pay. Government direct.
Go and sue the government. If you say that the government is not paying you money, I am going to hold the employer. I cannot think of anything else.
Kindly come to page 40,
I'll
55.
tell you,
I've
sir.
mentioned rupees 3,65,000. I have also requested in which account they have paid it. They have not intimated about the same.
The petitioner submits that a total sum of rupees 20 lakh 63,514 is due and payable.
No. Not it is as per record, Lord.
The details of the dues are clearly mentioned in the representation filed by the petitioner before the chairman of the municipality. Paragraph.
No, that is not.
Learned advocate representing the municipality submits that due to paucity of fund, the total dues of the petitioner cannot be paid. Stop. There are several employees. There are several retired employees of the municipality. Until the government grants aid to the municipality, it will not be possible for the municipality to arrange funds to disburse the terminal dues of the retired employees. Paragraph. The aforesaid submission of the municipality that payment of terminal dues cannot be made on account of paucity of funds cannot be accepted by the court. Stop. The municipality is the principal employer of the petitioner. Stop. It is the duty of the employer to arrange for funds for payment of the terminal dues of its employees. Stop. Paragraph. In view of the above, the instant writ petition is disposed of by directing the Navadip municipality to clear the terminal dues of the petitioner at the earliest, but positively within 31st of July 2024. Stop. Next. The paragraph. As the petitioner retired from service on 31st October 2019 and has not received his terminal dues.
No, 6th February he has
date.
got. 6th February 2019 he received the.
Accordingly, the petitioner will be entitled to receive the
interest
terminal dues along with interest at the rate of 7%, calculated on and from the due date till the date of actual payment. Stop. Paragraph. It is made clear that in the event the aforesaid amount along with interest is not paid within the stipulated time period, then the petitioner will be entitled to receive the amount with additional interest of 2%. That is 7% plus 2% is equal to 9% on and from the due date till the date of actual payment. Stop. It will be open for the municipality to seek for funds from the state government to clear the dues, if so advised.
Blood, fact is this, blood kindly record it. Dues as per report 2019, 3,65,000. And dues, revised pension, total 26,369. That
page 45, please come.
That is his submission.
No, page 45, please come. Check the PPO that is annexed. It is not his document. This is the document of the DPPG.
কোথায় 645 কোথায় পাচ্ছি 45ই নেই তো 35 36 no 45 here.
Page 45.
I don't know, I have sub this copy. They
show the PPO to him. Please show the PPO. Page 45, please see. Is it your brief or some other brief?
Oh, so next item 18. Sorry.
Is the whole problem.
You are making submission in respect of some other matter?
18, item 318, sorry, also.
Page 45, in the middle, see, net retiring gratuity, 5,47,500.
They have mentioned that I have released the provisional. That is not also correct.
No, no, he was mentioning in some other matter.
Not practice this, not dues. That amount is not dues, Lordship.
13 টা তো হলো।
My application. Lordship, notice of upgradation. This is also two affidavit of service, Lordship. First affidavit of service and then after upgradation. ROPA 2019 benefits. Lordship, petitioner, assistant teacher under Krishnanagar municipality retired on attaining superannuation on 30th of April 2021, Lordship. And for the month of May 2021, no pension was paid, and thereafter for the next 7 months, only ad hoc was paid, Lordship. And he is entitled to.
Where is the PPO?
PPO, Lordship, next. At page 10.
ROPA 2019, April 2021, you retired, right? What is, you have not received the amount mentioned in the PPO? Not received?
Not received.
Did you not receive the gratuity?
Gratuity receipt, Lordship.
Gratuity you received, then what is due?
Only the due, the difference of the amount for the period of 7 months from June 2021 up to December 2021.
Did you give any representation?
Lordship, at page
15?
Lordship, 15.
Briefটা চেঞ্জ হয়ে গেছে।
Through
Please come.
registered post. Speed post.
The petitioner is a retired employee of Krishnanagar municipality. His allegation is that a sum of rupees 57,276 is due and payable to the petitioner on account of his terminal benefit. Stop. A detailed representation filed by the petitioner is paragraph. In the absence of the municipality, it is not possible for the court to decide the issue conclusively. Stop. Next. In view of the above, the instant writ petition is disposed of by directing the chairman of the Krishnanagar municipality to take into consideration the representation filed by the petitioner on 16th January 2023 in accordance with law and release the dues of the petitioner
Along with interest, Lordship, as applicable.
at the earliest, but positively by 31st of July 2024. Stop. Next. As the petitioner was entitled to receive the amount long ago, accordingly, the petitioner shall be entitled to receive the said amount along with interest calculated at the rate of 7% per annum to be paid on and from the due date till the date of actual payment. Stop. Paragraph. Learned advocate for the petitioner is directed to forward a copy of the representation dated January 16, 2023 along with the pension payment order to the municipality at the time of communicating the order of the court. Writ petition disposed.
15, Lordship, revised enhanced family pension, Lordship, for a period of 30 months, Lordship, along with revised gratuity as per ROPA 2019, Lordship. Petitioner's wife was working as scavenger, Mozdoor, died in harness on 20th of February 2019, Lordship. Thereafter, Lordship, ad hoc pension was paid. But in terms of the 2019 benefits, the revised pension was not paid for a period of 30 months, Lordship. And the revised gratuity is also entitled. He is entitled, Lordship.
Please come.
I am for the state.
Lordship, two affidavit of service is there. After
Yes.
consideration, second affidavit of service.
The wife of the petitioner was an employee of Krishnanagar municipality. Stop. She died in harness on 20th February 2019. Stop. Pension payment order was issued on 8th November 2019.
Second September, Lordship, 2021.
Date is mentioned 2019.
Next, Lordship.
Page 11.
Page 11, Lordship. Then page 12, next PPO, 2nd September 2021.
And a revised PPO was issued on 2nd September 2021. Stop. Paragraph. Learned advocate for the petitioner submits that the amount mentioned in the PPOs have not been disbursed in favor of the petitioner. Stop. A sum of rupees 2,87,550 is due and payable to the petitioner. Due and payable. Is it 2 or is it 4 or 6?
Lordship, 2,87,550 for a period of 30 months. Rupa 19 revised pension along with Lordship gratuity, enhanced gratuity, 4,05,185.
So total is 6,92,000. Page 21, this is the figure that you have mentioned.
Lordship. Lordship.
692.
Yeah, Lordship.
Likhun to a sum of rupees 6,92,734 is due and payable to the petitioner. Stop. Paragraph. A representation has been made by the petitioner which is pending consideration at the end of the municipality for a considerable period of time. Paragraph. None represents the municipality. Stop. Affidavit of service filed in court is taken on record. Stop. In the absence of the municipality, it is not possible for the court to decide the issue conclusively. Stop. Next. In view of the above, the instant writ petition is disposed of by directing the chairman, Krishnanagar municipality to take into consideration the representation filed by the petitioner on 16th January 2023 in accordance with law and release the dues of the petitioner positively by 31st of July 2024. Stop. As the aforesaid amount was due and payable to the petitioner long back, accordingly, the petitioner shall be entitled to receive the amount along with interest at the rate of 7% per annum, calculated on and from the due date till the date of actual payment. Disposed.
Concrete.
None represents the petitioner at the time of call. Petitioners hobe. No accommodation sought. Writ petition stands dismissed for default.
My Lord, this matter is concerned, my Lord, my advocate on record has died. My Lord, I cannot now proceed, my Lord, without the advocate on record. My Lord, I will be only seeking, my Lord, an accommodation, if it is possible for your Lordship in the next monthly list.
Learned counsel representing the petitioner submits that the advocate on record of the
Mr. J.
petitioner
Mr. J.
has expired. Stop. Accommodation has been sought for this month. Stop. In view of such submission, let the writ petition appear in the monthly list of May 2024.
Extremely grateful.
Let notice be served upon the respondents intimating the next date of hearing.
Extremely grateful.
For 318, I am for the petitioner. Lord, this is related to the person, petitioner retired from service on 31st July 2018. Well, revised pension PPO issued. First PPO they have.
You have the brief?
Yes, Lordship.
All the papers are there in the brief. How many pages does the brief contain?
37.
37 pages?
Yes. Well, kindly come to page 29.
Yes.
That's the revised PPO.
Right.
Kindly come to clause 8. Clause 7. Additional gratuity 3,50,000. 3,65,000.
65.
That has not been paid, and area pension from 1st of the 1st of January 2020 to 21st of January 2021. That has not been paid.
But as
Because
per,
ROPA effect from 1st of January 2020.
but as per ROPA 2019, 3,65,000 and area pension 26,369.
Not paid.
Not paid. But due to shortage of fund, number of the
this is the epidemic service.
Number of the
It is for the municipality to generate funds.
How the fund? They are enhancing. Why is the government enhancing without payment of money? That is barred by law.
Why? Who is stopping
But
you?
they have the money to challenge the matter without
Government is the ultimate authority. আপনি বলে নিন আমি তারপরে বলবো
আরে সেটাই বলছি ঘটনাটা
আপনি
দেখো
বলে নিন যা বলার বলে নিন আমি যখন বলবো দয়া করে একটু সুযোগ
Please
দেবেন
come. The petitioner, please come. The petitioner is a retired employee of Navodip municipality.
That's self-sufficient due to shortage of fund. And as per ROPA 2019, 3,65,000 gratuity and 26,300.
So that is not correct. Not the areas pension below the 1st of January.
কি হবে অ্যাপিল হবে বাবা এসব ভুলভাল
Which is your representation?
Yes, page 37.
37 is the
Yes, that is mentioned there. 1st of
Very
January.
Blood as per PPO, revised PPO.
Yes, revised people from 1st of January to the.
He retired from service.
Number 1, serial number 1. Revised PPO from 1st of January 2020. Page 29.
On attaining his normal age of superannuation.
That is 31st July 2018.
On 31st of July
2018.
2018.
Yes.
Stop. Initial PPO was issued in his favor on 2nd July 2018 and revised PPO was issued on 1st February 2021. Stop. Paragraph. Grievance of the petitioner is that the amount indicated in the PPOs have not been disbursed in his favor till date. Stop. The amount that is due and pending in his favor has been clearly mentioned in the representation filed by the petitioner before the chairman of the municipality in January 2023. Stop. Next paragraph. Learned advocate representing the municipality submits that the entire dues of the petitioner cannot be cleared on account of the paucity of funds. Which item was that? The earlier item?
313.
Acha. আপনি লিখে দিন rest portion from 313. 313 এ যে নিয়েছে ওর শেষটা দিতে হবে.
Blood one submission blood
Yes.
is recorded 330 as per the revised
PPO.
PPO. Otherwise he claim other.
No, other.
Only one PPO. There is no.
So for the PPO.
Only the PPO account.
2019.
Yes, 2019 PPO. 319.
I appeal for the petitioner, my lord. Petitioner, if it is a petitioner is belonging to a person, a family, a downtrodden society, my lord. She applied for the Prime Minister Awas Yojana. Her name was thereafter she made an application under provision of RTI. Kindly comes to page 15. This was the reply given by the concerned officer, by block development officer, stating that her name exists in the priority number 84. Thereafter also, she has made representation for allotment. That has not yet been considered. Kindly direct the concerned district magistrate to consider representation at page 17. for allotment, my lord.
Please come. The petitioner seeks benefit under the Pradhan Mantri Awas Yojana scheme. Stop. Reliance has been placed on a communication made under the Right to Information Act 2005, mentioning that Sheikh Najera and Najera Bibi is the same person.
Same.
And probably, my lord, the cost title is also wrong.
That
my lord.
was my.
The son of such and such.
That
and my
was
lord,
my.
Yes, wife of.
That liberty may be granted.
there is
amend
two
the-
Sheikh
to-
Najera. My lord.
That
Najera
is at
Sheikh.
84, my lord. Kindly consider my page 16, my lord. Priority number 84, my lord. Priority number 84.
Priority number 84. Female.
Yes. No,
Sheikh Nazera.
84.
আচ্ছা কি বললাম
The correction.
ঠিক আছে তারপর হচ্ছে রিপ্লাই আন্ডার দি আরটিআই অ্যাক্ট বললাম wherein it has been now whereby the petitioner has been informed that her name exists in the priority list at serial number 84 of the minority category. Stop. Copy of the permanent waiting list in respect of the minority category showing serial number 84 was annexed with the reply made under the Right to Information Act. Stop. Paragraph. A representation has been filed by the petitioner. Filed by the petitioner seeking the benefit in terms of the aforesaid scheme. Stop. The said representation is pending consideration. Stop. Next. You addressed it to the district magistrate.
Yes.
Why can't the BDO do it?
BDO is a party, my lord. But
Yes. Why is the district magistrate
the
required
district
to
magistrate under the scheme, my lord, the district magistrate is the
authority
to
disperse
allotment.
the money?
Money.
Acha, paragraph into. As it appears that the representation filed by the petitioner is pending consideration at the end of the district magistrate Howrah.
Bakura.
Bakura?
My lord. Yes, Bakura.
Now I'm going to dismiss the writ petition with costs.
Kindly, my lord.
Your lordship, kindly direct the BDO. BDO, probably it is Vishnupur development block. Also, my lord, there is a representation page 13 annexure P2
No, that's RTI.
for the RTI.
RTI.
And BDO give the RTI reply. So, my lord, I think, my lord, the BDO is a
BDO is the SPIO. Joint BDO is the SPIO. That is the reason. But then under the scheme, the district magistrate has enough powers.
Yes, ma'am. That is there.
আচ্ছা কি বললাম ওটা হবে বাঁকুড়া Accordingly, the district magistrate Bankura is directed to consider the representation filed by the petitioner in accordance with law at the earliest, but positively within a period of 12 weeks from the date of communication of this order.
Now, my lord, the election proceeding is going on. Your lordship kindly give some more time. Because
I think 4 months. 4 months.
I'm grateful. Man.
Next, the district magistrate shall pass a reasoned order and communicate the same to the petitioner. Stop. Paragraph. Learned advocate for the petitioner is directed to forward a copy of the representation received in the office of the district magistrate on 4th April 2023 along with the reply under the RTI Act 2005 and the priority list to the district magistrate at the time of communicating the order of the court. Stop. Paragraph 3. Leave is granted to the advocate on record of the petitioner to amend the description of the petitioner and the respondent number 2 in the cause title of the writ petition. Writ petition disposed. What is to be done with y'all? So busy, cannot check up.
My lord, it is copy paste.
I understand.
Lord, I appear for the petitioner. Okay, Pinaki Dhol. But Mr. Pinaki Dhol appears for the state respondent. State is the answering respondent.
Who is appearing?
Mr.
Pinaki Dhol. Where is he? He was here just now.
He has been served twice, even after.
Just now he was here. What is the matter?
Lord, matter relates to, my lord, enhancement of remuneration of a Group D casual worker. My lord, there are various circulars and government orders of the state of West Bengal issued by the Department of Finance. And in violation of this order, my lord, they are not enhancing my remuneration. One-time enhancement was made up to 8,500. Just implementation of the order for enhancement, my lord. I may place the case before your lordship. May I?
No, but thing is, the benefit of the orders that you are seeking, that is in respect of the state government employees.
No.
You are the?
No. State casual workers and, my lord, daily rated workers and other workers, they are not the state government employees.
Yes. So how will you get the benefit?
Yes, this is for us.
It is mentioned. Show me the memo.
Yes, my lord. Your lordship, kindly have a look, page, my lord. Before that, my lord, it has been, this is 4th round of litigation.
4th round of litigation. All right. 6.
Your lordship, kindly have a look, my lord, page 31 first. I'll show it to your lordship.
Is there any reasoned order that you are challenging?
Yes.
Where is it?
That is page last.
Last page, it has been rejected.
No.
What is the?
My lord, the commissioner of Panchayat said that the principal secretary or the additional secretary is the authority. He is not the authority for so and so doing this. My lord, apart from this, your lordship, kindly have a look, page 76 once.
Has it been decided on merits? No. The commissioner, did he decide it on merits or did he say that he is not the authority and accordingly he cannot do it?
Decided on merit. Entire merit has been decided.
And
entitlement has been fixed.
Yes.
And thereafter he said that enhancement can be done by the additional secretary. I have no authority.
Very well. Has the commissioner come to a conclusive finding that you will be entitled to the enhanced amount?
In that line, it has been issued.
Please show me.
My lord. Page 85.
85.
On last paragraph.
Yes.
Relevant portion I am saying.
Yes.
On careful consideration of the submission and materials placed before me by both sides and after careful perusal of the relevant provision of the different circulars and orders the state government in this regard, I find that the petitioner has been engaged since 2001 at the office of the Kontai 1 block, has been made to perform tasks in the office and different capacities. A statement was also issued by the BDO certifying more than 240 days of engagement per year from 2000. He is continuing to be engaged thereafter as well. Different BDOs also certified his conduct and his good services during the period. He was also drafted in many significant and important works like election works, relief works, etc. The fact that He was not engaged against any sanction post as required to come under the purview of memo number so and so 16/9/2011 of the Finance Department has become virtually a non-issue considering the observation made by the Honorable Justice Subrata Talukdar in his solemn order dated 7 January 2019. Though his prayer for engagement with the concerned BDO office since January 2001 for gardening and supplying drinking water to office staff has been accepted by the BDO, the nature of administrative approval of this usual office procedure behind this engagement remains obscure. Despite his long association with the different administrative work as BDO office since 2001 and his continuance in the office till this day is such an evidenced matter as cannot be brushed aside in a single stroke. In view of the finding as discussed above, fixation of remuneration of the petitioner in accordance with the relevant circulars of the government now become an imperative. But before deciding the fixation of remuneration along with the timeline under provisions of memo number so and so dated 20th May 2013, the Finance Department, it is felt necessary as a precondition to formally decide the settle the issue of eligibility to come under the fold of the memo number dated 16th September 2011. At first, on thorough perusal of the said government order, it transpires that the Commissioner, Panchayat and Rural Development, West Bengal, being the head of a directorate, does not have jurisdiction to decide on the prayers regarding the entitlement thereto. The power of according final approval of such application prayer has been vested to the additional chief secretary, principal secretary, secretary, to the head of the concerned administrative department as per paragraph so and so, memo dated so and so of the Finance Department after exercising necessary checks and balances so and so. Keeping this, but next paragraph, last but one, keeping this jurisdictional constraint in view, the instant matter with the entire case record are referred to the HOD in the Department of Panchayat and Rural Development, Government of West Bengal for final disposal of the prayer of the petitioner. It's still awaited. My Lord, before that, may I show one thing, my Lord? Entitlement has been fixed by earlier occasion by this Honorable Court, my Lord, that he is entitled. That has been settled.
Please show me 9008F, 16th of September 2011, Finance Department.
All right, I will show it to your Lordship certainly. Before that, may I show for it will make it easy.
What?
It's page 76.
76.
I'm just reading this order, madam. In terms of GO number 9008FP dated 16th September 2011 and memo number so-and-so 2013 dated, the Finance Department Audit Branch, Government of West Bengal, memo number so-and-so issued from the Land and Land Reforms Department, Writers Building, Government of West Bengal, the following contractual, daily rated workers, casual daily rated workers, Group D, mentioned below have rendered service for more than 240 days in each year and less than 10 years continuously are hereby allowed the benefit of memo dated 16th September 2011 on Royal Consolidated Remuneration 5,000 only per month with effect from 1/8/2011 to 30th April 2013, and thereafter second memo was issued on that basis as per memo number so and so 20th May 2013 7,000, and thereafter third memo that is with effect from 1st May 2013 onwards, and memo has been issued time to time. And my lord, these number 21 numbers of casual and daily rated workers have been granted by the district master and controller, collector, Purva Medinipur. They have issued and they are getting. But the commissioner of the Panchayat department, he says that I have no authority. On the contrary, the district Purva Medinipur district magistrate passed the order and they are getting everything. And I'm showing the my lord's query that 16th September 2011. My lord, that is at page, my lord, 34.
Is there anything mentioned as to who is the appropriate authority to pass an order in respect of this memorandum?
By this honorable court last occasion, and my Lord Justice Subrata.
No. In this memo, is it mentioned? Who is the appropriate authority?
Memo, it has not been specifically mentioned. I have not.
Final approval will be given by the ACS Principal Secretary,
No, that
after issuing necessary checks and ensuring that ineligible person do not get the benefit. This is 36, it is mentioned.
That has been given, my Lord, in the paragraph 14. But it has been thereafter, my Lord, matter has been taken into consideration by this honorable court, and the court has.
Yeah, understand is for the director to reiterate that henceforth no words of change. Please come. None represents the respondents. Stop. Affidavit of service filed in court is taken on record. Stop. The order dated 4th July 2022, passed by the Commissioner of Panchayats and Rural Development, Government of West Bengal, Directorate of Panchayats and Rural Development, is impugned in the instant writ petition. Stop. Paragraph. It appears that the said order was passed allegedly in compliance of the direction passed by this court on 2nd February 2022 in WPA 8177 of 2020, filed by the petitioner. Stop. In the said order, the court directed the Commissioner, Panchayats and Rural Development, to grant an opportunity of hearing to the petitioner, as also the concerned block development officer, and to pass a reasoned order in consultation with all documents filed by the petitioner and the relevant circulars issued by the government from time to time applicable to casual workers. Stop. The court directed the Commissioner to consider the matter in its true letter and spirit. Stop. Paragraph. The Commissioner afforded an opportunity of hearing and took note of all the documents placed at the time of hearing. Stop. The Commissioner was of the opinion that fixation of remuneration of the petitioner in accordance with the relevant circulars of the government has become imperative. Stop. Before fixation of remuneration of the petitioner, along with the timeline as mentioned in the memo number 4011-F dated 20th May 2013 of the Finance Department, it is necessary, as a precondition to formally decide and settle the issue of eligibility of the petitioner to come under the fold of memo number 9008-F dated 16 September 2011. Stop. The commissioner was of the opinion that being the head of the directorate, the commissioner does not have the jurisdiction to decide the prayer regarding entitlement of the petitioner. The power of according final approval on such application/prayer has been vested on the additional chief secretary/principal secretary/secretary. Stop. The commissioner opined that once the decision on the question of being covered is taken by the head of the department, questions on subsequent fixations of enhanced remuneration may be determined by the department. The commissioner referred the entire case records to the head of the department, Panchayats and Rural Development, for final disposal of the prayer of the petitioner. Stop. Next. The petitioner submits that the commissioner ought to have taken a decision without referring the matter to the head of the department. Stop. Next. The petitioner relies on an order of the district magistrate and collector, Purba Mednipur Tomluk, dated 28th October 2015, wherein the district magistrate and collector, in terms of GO number 9008-F within bracket P, dated 16th September 2011, and in consultation with the subsequent government orders, directed payment of enhanced remuneration to the employees. Stop. Paragraph. It has been submitted that if the district magistrate and collector can take a decision relying on the said memo, said government order, there is no reason as to why the commissioner could not take a decision in the matter. Stop. Paragraph. From the documents annexed to the writ petition, it appears that the court, vide order dated 2nd February 2022, in the earlier writ petition filed by the petitioner, being WPA 8177 of 2020, specifically directed the commissioner, Panchayat and Rural Development to decide the issue. Stop. If the commissioner was to decide the issue, stop. The commissioner ought to have acted in accordance with the direction passed by the court. Stop. If the commissioner was of the opinion that the same is to be decided by some other officer, then leave ought to have been obtained from the honorable court for a direction for by the competent officer. Stop. In the absence of a formal direction, comma, it was absolutely improper for the commissioner to refer the matter to the head of the department, comma, Department of Panchayats and Rural Development. Stop. When the court, after hearing the submission made on behalf of the parties, directed the matter to be decided by the commissioner, comma, he ought to have decided the same himself and should not have referred the same to any other authority. Stop. Next. Assuming that the commissioner in terms of the subject memo decided to refer the matter to the head of the department, comma, then the commissioner ought to have made sure that the head of the department decides the issue and reverts it to the commissioner for passing final order in the matter. Stop. The commissioner has simply shrugged off his responsibility and shifted the burden of consideration upon somebody else. Stop. Next. In view of the above, the Commissioner of Panchayats and Rural Development is directed to either consider the issue himself or to obtain the order from the concerned officer and revert the matter to the petitioner upon final conclusion of the prayer of the petitioner. Stop. Next. The petitioner ought not to have been directed to kept waiting for a subsequent order to be passed by the head of the department. Stop. Next. The commissioner is accordingly directed to act in terms of the direction passed herein above at the earliest, but positively within a period of 4 months from the date of communication of this order. 8 petition stands disposed of.
We're grateful to your lordship. But earlier occasion, commissioner has passed the order on the basis of this honorable court. At that point of time, disposed of and enhanced up to 8,500. Now at this stage, they are saying that approval is required. The petition pertains to my lord. The Vidhannagar municipality, my lord, directed the petitioner to make payment of the, my lord, property tax, which was, my lord, in the year 21-22 was 1,89,000 and what. Now, my lord, it has been enhanced to, my lord, 16 lakhs without affording any opportunity of hearing, without serving any notice. My lord, I had no intimation. So the fact of the case remains, my lord. My lord,
tell me first whether individual notices are served.
No.
Are required to be served?
My lord, unless, my lord, the petitioner is, my lord, hard out, my lord, unless the petitioner, my lord, puts her objection, my lord, corporation, my lord, assess the, my lord, annual valuation from 1,89,000 to, my lord, 19 lakhs. And, my lord, without, my lord, serving any notice, without affording any opportunity of hearing, my lord, I represented before the, my lord, the municipal authorities, they kept silent over that, my lord, representation. Nothing has been done. And not only that, my lord, I paid the municipal taxes up to the year 21-22. Thereafter, my lord, no bill was, my lord, served upon me. My representative, my lord, went to the office of the, my lord, municipalities.
whereupon it appears, my lord, the bills are lying in the record of that of the assessment department. From that record, my lord, I came to learn that the assessment has been enhanced from 1,89,000 to 19 lakhs. And my lord, sum of rupees 16 lakhs has been shown as area.
Very well. Page 53 is your representation.
My lord, page 53 is the representation, my lord.
What is the stand of the corporation?
Yes, my lord, the premises in question was leased out to one Fab India, my lord, and that lease deed has been provided to us through other departments. Now, my lord, as far as the annual valuation is concerned, if your lordship kindly sees,
Fab India was my tenant, my lord.
just 1 second.
Was tenant. My lord, they vacated the premises.
Look, if your lordship kindly sees the wordings of section 119, my lord, the relevant wordings is that, well, I'm reading out, my lord, for your lordship's convenience, that the annual valuation of a holding comprising vacant land and building shall be deemed to be the gross annual rent, including service charge, if any, at which such vacant land and building might at the time of assessment be reasonably expected to let from year to year. So they actually had a tenant. They say that that tenant today is not there, but at one point it was there. And from that, we have seen what is the reasonable rent which can be fetched from the premises. On the basis of that, we have fixed the annual valuation multiplied by 90% as required. 10% is left out for maintenance and repairs. So 90% of that rent, of that valuation we have done. And that same agreement said that if it subsists, it will be enhanced by 15% for every 3 years. So after every 3 years, we have also given that, because that also we found to be a reasonable rent which can be fetched from the property. So what valuation we have based it on is not divorced from what he has already utilized the property for. So it is not baseless and not according to our whims. So that is the basis on which it has been done. And the rest of it, my lord, how the property tax is to be calculated, my lord, that is also, my lord, provided in the statute itself, my lord. That is preparation of valuation is 123 and rent is 108. So we have proceeded on that basis.
Was a hearing required?
My lord, hearing is not contemplated under these provisions. At least I invite my learned friend to show if I have missed it. So, my lord, no hearing is contemplated under this. But if the basis is to be communicated to him, my lord, on the basis of the representation, we can communicate the basis to him.
The hike is quite high.
Well, now, kindly see, my lord, he on a self-declaration, self-assessment, on a self-assessment, he was paying certain rent. He himself did not come and disclose to us that this is the reasonable rent that I am fetching from the property. We have obtained that agreement from other sources.
Neither did he disclose that the tenant has left.
Not that. I am not even going into that aspect. What we are only seeing is that if he can fetch it from one tenant, he can fetch it from another corporate entity also.
Please come.
My lord, may I rely upon the division and judgment of this honorable court? Lordship, kindly have it to page 26.
What does it say?
My lord, hearing is absolutely necessary. Unless, my lord, the hearing is done, the hearing officer cannot assess, my lord, whether I have tenant or not. Or, my lord, that is, my lord, I have to file objection to the hearing officer. My lord, that tenant was there. I intimated the municipalities. The tenant left the premises. My lord, all these things are, my lord, have to be placed on record.
At the time of induction, did you intimate that this is the tenancy, this is the rent that I'm fetching from there? Did you intimate?
That I don't have an instruction, but
you don't have.
But no, my lord, I have no instruction.
For which period was the tenant over there?
My lord, up to 2016.
But the assessment, my lord, when the assessment was made,
December
2016. At that time, tenant was not there.
For which period was the tenant
21, my lord. He left.
From when?
That I don't know.
December 2016 to November.
Up to, my lord, the tenant was there. They terminated.
That means 5 years, 16 to 21.
But, my lord, the assessment has been made in, my lord, in the year 21-22. It was, my lord, 1,89,000. My lord, 23-24, my lord, all of a sudden, my lord, 19 lakhs. And, my lord, so far, my lord, kindly have a look to the judgment, my lord, division judgment of this, my lord, kindly have a look, my lord.
Petitioner is aggrieved by the excessive hike in the
173.
annual valuation assessed by the Bidhannagar Municipal Corporation. Stop. The petitioner submits that the annual valuation has been assessed. Petitioners have submit that annual valuation has been assessed without giving any opportunity of hearing to the petitioners. An objection to the enhancement of annual valuation is pending consideration before the end of the Bidhannagar Municipal Corporation. Stop. Next. Without going into the merits of the claim of the petitioner, as it appears that an objection is pending consideration at the end of the corporation for a considerable period of time. Accordingly, the instant writ petition is disposed of by directing the commissioner will be the appropriate.
It should be the joint municipal, respondent number 4.
The joint municipal commissioner, being the respondent number 4 herein, to take a decision on the objection filed by the petitioners in accordance with law, after giving reasonable opportunity of hearing to the petitioners to place documents in support of their stand. At the earliest, but positively within a period of 4 months from the date of communication of this order, a reasoned order shall be passed and communicated to the petitioners immediately thereafter. Are you taking any coercive steps now?
For the timing,
No.
we have not taken, but it is also outstanding for a long time.
Well, outstanding, my lord, I had no intimation.
Very well.
May I have the affidavit of service?
Yes, service taken on.
At least old rate he can put in.
No, that is paid, my lord. That is paid up to the year 21, 22. I have no objection. If
We are
my
in
lord,
24
my
now.
lord, if they take, my lord, earlier valuation, I have no objection. I will pay that.
22, 23, same time. 22, Miller, the petitioner retired from service on 31st of May 2021. Received a provisional pension, but till that no PPO has been issued.
Where is the PPO?
No PPO has been issued.
You retired on
31st May 2021. Lord, can you take up the next matter? I have shown some papers. 23, same matter.
देखिए एक तो
Here in this case, retired on 30th November 2019. Lord, kindly come to page 30. Lord, page 29 first. Joint Secretary requested to submit some papers. Page 29.
Yes.
And the chairman also submitted papers. In spite of that, till date, I have not received any papers. Nothing.
Pension case.
Of the municipality. I have served the municipality also.
Where is your appointment letter and all those things?
Appointment letter at page. Page 16 first.
What is the municipality stand?
Municipality has forwarded everything to the DLB, my lord.
DLB has not taken any
DLB has
decision.
not taken any.
Well, in the similar circumstance, other petitioner retire, other person retire and getting
One person has
retire and
getting the pension.
Why is the others not getting?
Two persons who have filed item 22 and 23.
Yes.
Same person.
Municipality chairman and executive officer, my lord, immediately after taking the application forwarded the DLB for approval. But from their end, my lord, nothing has been done.
Please come. The petitioner is a retired employee of Panihati municipality. Stop. Allegation is that the terminal benefits is that his terminal benefits have not been disbursed till date. Stop. Paragraph. Representing the municipality submits upon instruction that all documents in support of the dues of the petitioner have been forwarded to the Director of Local Bodies in due time, but there is no response from the end of the Director of Local Bodies till date. Stop. Paragraph. None represents the Director of Local Bodies. Stop. Affidavit of service is taken on record. Stop. Paragraph. It appears that the petitioner retired from service on 31st of May 2021, but till date has not received his terminal dues. Stop. It is the duty of the employer to ensure that the employee is paid the terminal benefits immediately after retirement. Stop. Nearly 3 years will be complete, but neither the municipality nor the Director of Local Bodies have taken any steps to redress the grievance of the petitioner. Stop. Next. In view of the above, the municipality is directed, the chairman of the municipality is directed to follow up the matter with the Director of Local Bodies to obtain necessary approval if required, and thereafter take steps for disbursal of the terminal dues of the petitioner. Stop. Steps shall be taken in the matter at the earliest, but positively within a period of 4 months from the date of communication of this order. Stop. In the event calculation of the terminal dues takes some time, comma, then provisional pension.
Provisional pension I am getting.
Oh, you are receiving?
Yes, both the cases I have received the provisional pension.
The writ petition stands disposed.
My lord, one thing, my lord, direction may be given to the DLB also, my lord.
You follow it up.
I will, but DLB as well as my lord. Otherwise, they will not.
The Director of Local Bodies is directed to respond, directed to promptly respond to the approach of the municipality and ensure that the retired employee receives his dues within the time limit as specified herein above.
Next matter only below 5 years and below 5 years.
My lord, another
thing. 2031, 30th November 2019. 5 years already over.
Date ta change hobe. Date of retirement is
30th November 2019. That is page 15, paragraph 15 I have mentioned.
In the list of dates you have not mentioned.
Not mentioned. Paragraph 15 I have mentioned. Sorry. Paragraph 15 I have mentioned.
You are claiming your terminal dues and you do not disclose your date of retirement in your list of dates.
Paragraph 15 I have mentioned.
Retirement date 30th of November 2019.
Yes.
এটা তো 5 বছর হয়ে যাচ্ছে। It will be 5 years. আগেরটাতে 3 বছর লিখেছিলাম না, এটা 5 বছর।
My lord, one thing, my lord, instead of chairman, my lord, you may be
executive officer.
Paniati municipality, my lord, problem is going on.
আচ্ছা, ওখানে না চেয়ারম্যান অফ দ্য মিউনিসিপ্যালিটি বলা আছে, ওটা হবে এক্সিকিউটিভ অফিসার অফ দ্য মিউনিসিপ্যালিটি। চেয়ারম্যান পানিহাটি মিউনিসিপ্যালিটি বলেছে, সেটা হবে এক্সিকিউটিভ অফিসার।
My lord, I appear for the petitioner, my lord. My lord, the petitioner is an owner of a property. My lord,
owner of a property.
Petitioner is the owner of a property where, my lord, the municipality has in front of the property, my lord, embedded, my lord, steel barricades, my lord. I had, my lord, through the tenant, my lord, who was running the shop room. It's a commercial space. He had previously approached this court, my lord. If your lordship straight away comes to the order passed by this court at page 24, then I'll show your lordship the, my lord, position of the shop room today. My lord, page 24 is the order passed in the tenant's, my lord, writ petition. My lord, the last paragraph.
Yes.
Second last paragraph. It is submitted that pursuant to service of the writ petition, the barricade in front of the shop has not been removed. Pictures have been produced before this court, which show that no such has been removed. No such obstruction to the entrance of the petitioner's shop exists. Thus, the court is of the opinion that no protective order is required to be passed at this stage. Municipal authorities have taken care that the entrance to the shop room of the petitioner is not blocked in any way. Further prayer of the petitioner for change of alignment of pavement cannot be entertained, as this step has been taken for public interest, and such action of the authority for public good and beautification should not be interfered with. The grievance of the petitioner has been addressed. Ingress and egress to the shop is free. However, it is made clear that the entrance of the petitioner's shop shall remain as it is, and further obstruction should not be placed in front of the door, blocking free entry and exit from the main road. My lord, after this order, my lord, there was for some time, there was no, my lord, problem with regard to, my lord, ingress and egress to the shop room. Now, if your lordship kindly comes to page 26 onwards, my lord, the photographs would, my lord, demonstrate, my lord, how they have again, my lord, put the same barricade, my lord, so that, my lord, I don't even have access to this, my lord, shop room at all, my lord. If your lordship sees from the left-hand corner to the right-hand corner, in fact, page 26, 28, lordship may look, my lord, from a different angle. Lordship will get a better picture, my lord, of what has happened, my lord, in front of the property. And it is not that it is, my lord, a barricade on the footpath. It is, my lord, entirely blocking my ingress, egress, and my right to carry on business has been, my lord, affected by reason of this. And this is exactly what, my lord, in the previous writ petition, the learned judge had recorded that this cannot be done. Now, my lord, immediately when this was done, I write a, my lord, letter to them. My representation is at page, my lord, 29.
On the last occasion also, nobody appeared for the Jangipur municipality in the earlier matter.
No, my lord, ultimately, yes. But we had filed the affidavit of service. My lord, I have served. In fact, we had mentioned this matter for upgradation. Lordship was kind enough to upgrade. We have also, my lord, communicated them that it has been upgraded. That service is also there, my lord. Both the services are there. My lord, my communication is at page 29. My lord, after narrating the facts and, my lord, about the order, my lord, kindly comes to page 31, which is internal page 3 of the letter. The second paragraph. On or about 20th May 2023, at about 10 a.m., your men and agents have once again installed barricade on the front portion of my client's shop, thereby obstructing my client's ingress and egress into the said shop room. The installation of barricade by you in front of the door of my client's showroom and blocking free entry and exit from the...
The grievance of the petitioner is that Jangipur municipality has put up railings in front of the shop room of the petitioner in such a manner that free ingress and egress to the shop of the petitioner is completely blocked. Stop. Photographs of the railings in front of the petitioner's shop room have been annexed to the writ petition. Stop paragraph. It appears that in a previous round of litigation, the court in WPA 16529 of 2021, video order dated 7th October 2021, in Sanvi Retail Private Limited and another, page 24, versus the chairman Jangipur municipality and others, directed that the entrance of the petitioner's shop room shall remain as it is, and further obstruction should not be placed in front of the door, blocking free entry and exit from the main road. Stop. Next. The Photographs annexed to the writ petition suggest that the pre-entry and exit to the petitioner's shoproom has been infringed by way of the railings that have been put in front of the said shoproom. Stop. An objection has been filed before the chairman of the municipality, which is pending consideration for a long period of time. Stop. Next. Paragraph, as the municipality is not represented, comma, the issue cannot be decided conclusively. Stop. In view of the above, the chairman of the municipality is directed to consider the objection filed by the petitioner in light of the order passed by this court on 7th October 2021 in WPA 16529 of 2021. After giving an opportunity of hearing to the representative of the petitioners at the earliest, but positively within a period of 60 days from the date of communication of this order. Yes, please.
My lord, I was, my lord, only thinking, my lord, since they have not turned up in the previous round also.
Yes.
My lord, it has remained pending almost for a year now and another 60 days. I was only, my lord, thinking, my lord, if lordship permits, I can give them another notice and come back so that if lordship is inclined to, my lord, dispose it of, my lord, the municipality can be directed in line of the, my lord, previous order.
The previous order was obtained by somebody else. You want to take the benefit of the said order?
My lord, he is my tenant.
Tenant. Whatever. Disposed.